on my end. I understand that's because I'm actually here at the courthouse as opposed to at my home, and so that may be some of the connectivity issue. So bear with us all. Part of it is that we have a different platform than Zoom, and I think that may be creating some issues. So I'm hoping not to lose anybody over all of this. And let me make sure or confirm that I have the right parties. I have what's been identified as team number 7 for the prosecution. Is that accurate?
Yes, Your Honor.
And I have team number 2 for the defense. Is that accurate?
Yes, Your Honor.
All right. Let me hold on just a minute. That's not it. There is an oath that I'm supposed to administer, but I was having trouble saving that oath. All right, and now I'm having trouble seeing people again. There we go. All right. All right. Does anyone have the oath handy that they could let me have the prosecution read it to the participants? If they would do that, please, because I cannot access the one that I have. I can access it, but it's really, really small, and I'm really, really old, and so it's hard for me to see something that is that small. So let's try that.
Your Honor, permission to screen share the oath?
Please.
I believe this should be it.
That is it. Okay, thank you. I can do it from there. Team members, please raise your right hands. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
I do.
I do, Your Honor.
All right. Witnesses, do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Gallery members, including teacher and attorney coaches, family members, and friends, please raise your right hands. Do you promise to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round? I assume that there was affirmation there. Scoring panelists, please raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
I do. Yes, Your Honor.
I'm one of those as well, so I do as well. All right. With that, what is the case name that we are trying here? Prosecution?
The State of Colorado versus Avery Becker.
Becker, all right. And is the prosecution prepared to proceed to trial?
After a few preliminary matters, Your Honor.
Okay, and is the defense prepared to proceed to trial?
Yes, Your Honor.
All right, let's go back to the prosecution for a moment. You had said that you had a few preliminary matters that you wanted to address. What are those?
For virtual competition, may we consider the stipulations and our trial roster published to the jury, opposing counsel, and Your Honor?
Defense, do you have an objection? Does the defense have?
Sorry, can they repeat the objection?
It's actually a request, just that well, I'll let Ms. Delfolo, if you could state that again, please.
That the court consider the stipulations and our trial rosters published to the jury, opposing counsel, and Your Honor.
Thank you. We have no objections to that as long as you post your roster in the chat. We'll also publish our roster as a PDF file in the chat as well so that you guys could have that.
All right, then the offer is deemed admitted, and is the prosecution then prepared to proceed?
A couple more notes, Your Honor.
Okay,
Although rule of the competition 5.1.1 requires attorneys to stand during opening statements and closing arguments, because we are virtual, we ask that the court waive that requirement for both teams.
that's appropriate. I can't tell whether or not you're standing anyway, so that's just fine.
And finally, Your Honor, permission to introduce our team.
I would like that actually, and well, I'll get to it one at a time when we get to the opening statements and those sorts of things, but go ahead and introduce your team, please.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Olivia Dalfolo Daly. I am attorney number 2, and I will provide the direct examination of Alex Cifuentes and the cross-examination of Professor Blake Van Owen. I will also give the opening statement.
Your Honor, opposing counsel, and members of the jury. My name is Jaylee Hepner. I am providing the direct examination of Detective Jordan Markowitz and the cross-examination of Taylor Perkins.
Your Honor, opposing counsel, and members of the jury. My name is Zoe Mans-Jackson. I will be your third attorney on the side of the prosecution, and I'll be providing the direct examination of Kyle Kuzak, the cross-examination of Avery Becker, as well as the closing argument. Our witnesses will now introduce themselves.
Good evening, Your Honor, opposing counsel, and members of the jury. My name is Eleanor Briggs. I am Detective Jordan Markowitz, and I will be your first witness today.
Your Honor, opposing counsels, and members of the jury. I am Samuel Kruzlik, and I am Alex Cifuentes, your second witness.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Peter Briggs. I am Kyle Kuzak, and I will be the third witness today.
All right. Are there any others? Ms. Dalfolo Daly. Am I getting that name correctly?
Dalfolo Daly, yes.
Okay, all right. Are there any other members that you wanted to introduce at this time, Ms. Dalfolo Daly?
No, Your Honor.
All right. Does the defense wish to introduce its team at this time?
Yes, Your Honor.
All right.
Your Honor, members of the jury, opposing counsel, my name is Katie Hunter. I will be directing Blake Van Owen and crossing Alex Cifuentes, along with giving the opening statement.
All right.
Your Honor, members of the jury, and opposing counsel, my name is Ginger Hartman. I will be giving the direct examination of Avery Becker and the cross-examination of Jordan Markowitz.
Your Honor, members of the jury and opposing counsel, my name is Nicholas DeSalvo. I will be providing the direct examination of Taylor Perkins, the cross-examination of Kyle Kuzak, as well as delivering our closing argument. And at this time, our witnesses would like to introduce themselves.
Yes, please.
Your Honor, members of the jury, and opposing counsel, my name is Crystal Caruana, and I am Avery Becker.
Your Honor, members of the jury and opposing counsel, my name is Chibuka Anuka, and I am Taylor Perkins.
Your Honor, opposing counsel, and members of the jury, I'm Haley Maurer, and I'm Blake Van Owen.
All right. Are there any other introductions that we need to address at this point in time, Ms. Dalfolo Daly?
No, Your Honor.
Ms. Hunter?
No, Your Honor, but at this time, in addition to the preliminary matters that the opposing counsel has already addressed, may we add to that list?
You can try. Go ahead.
Your Honor, we request the court's preferences on redirects and recrosses.
Can you explain that a little bit more?
Your Honor, what I'm asking is if recrosses and redirects will be allowed within this trial.
Briefly.
Thank you, Your Honor. Your Honor, we were in Pursuant to Rule 7.4, when an exhibit is shown to a witness, a member of the examining attorney's team shall make that document available to all participants via screen sharing or similar technology. Additionally, exhibits or other documents posted in this matter will be deemed not to have been shown to the jury unless they are admitted into evidence and formally published to the jury.
That's the rule. Are you requesting that they follow the rule? What is it that you're requesting?
Yes, I'm also just making that aware that that's the mode that we're going to be sharing our exhibits.
Okay.
And that just some clarification for the members of the jury as well.
Prosecution, do you agree?
No objection, Your Honor.
All right. Ms. Hunter, do you have anything else?
No, Your Honor.
All right. I'm not exactly sure who it was that I was talking to. I'm sorry. I thought it was either Ms. Hartman or Ms. DeSalvo.
Yes, Your Honor. It was Ginger Hartman.
Right? Yes, ma'am. Anything else from the defense side?
No further preliminary matters, Your Honor.
All right. All right. Then let's go ahead and start the trial. We're here in the case of People versus Becker. And I understand that both sides are prepared to proceed. Does the prosecution have an opening statement it wishes to make?
Yes, Your Honor.
All right, go ahead and proceed.
Your Honor, opposing counsel, and members of the jury. Avery Becker got in, got out, and got even. On March 6, 2020, Avery Becker got into mock trial coach Mackenzie Brackman's home and got out while having trashed the place. In those course of events, Mackenzie Brackman was murdered and Avery got even. The prosecution will present 3 witnesses in court today. First, you'll hear from Jordan Markowitz, who is a lead detective and expert in this case. Detective Markowitz will place Avery at the scene and time of the crime through cell tower evidence, a field she's an expert in. Detective Markowitz will also detail how she arrived at Avery being the culprit, including murder. Next, you'll hear from Alex Cifuentes, Avery's own friend and teammate. Alex will speak of the rising tensions between Avery and Brackman, from Avery's bad habits to vandalism to texts where Avery threatens to do exactly what happened. Finally, the prosecution will present Kyle Kuzak, who will walk you through exactly what happened at the crime and is an expert witness. Next, the defense will provide 3 witnesses of their own. Taylor Perkins. Taylor is Avery's friend who's loyal to a fault. Taylor will speak of the relationship between Avery and Brackman, as well as Avery's increasing reactions. Taylor also holds doubts about whether Avery's phone was ever actually taken, which is the basis of their alibi. Taylor has saved Avery before and is trying to do so again here today. There's also Professor Blake Van Owen, who is an ex-police officer and a paid expert who only ever testifies for the defense. Van Owen offers her own assumptions to this case and suspects someone completely different who committed the crime. Finally, there's Avery Becker, the defendant. Avery was a student on the high school mock trial team under Coach Brackman. Tensions were high between the two, and Avery often lashed out, whether it be storming out of practice, vandalism, breaking into and trashing a home. And now, Mackenzie Brackman is dead. The defense will try to say that Avery is innocent, but Avery has lied before and will do so again. Why we are here today is no light matter. There is a dead body and a bloody knife. This is no mock trial. This is no fake case high school students worked on in their free time from Halloween to now. A hothead murdered a man in cold blood. On the shoulders of the prosecution rests the burden of proof, to prove beyond a reasonable doubt that Avery Becker is guilty. Avery unlawfully and knowingly broke into Mackenzie Brackman's home with the intent to commit criminal mischief. Mackenzie Brackman was murdered. At the end of the presentation of evidence, my co-counsel Zoe will ask you to find Avery guilty because Avery Becker got in, got out, and got even. Thank you.
All right. At this point in time, the defense has an opportunity but is not required to give an opening statement. I want to remind the jury that they need to keep an open mind and the burden of proof is always on the prosecution. Does the defense wish to give an opening statement at this point in time?
Yes, Your Honor.
Go ahead.
Your Honor, members of the jury, opposing counsel. The truth, the whole truth, and nothing but the truth is what the defense is here to deliver. The truth is there were other murder suspects in this case. The truth is Avery Becker has an alibi. The truth is Avery Becker is innocent and is pleading not guilty to murder in the first degree and second degree burglary of a dwelling. Avery Becker, a senior at Colorado High School, was on the mock trial team with Taylor Perkins and Alex Cifuentes. Now, Avery and Coach Brackman admittedly had a rocky relationship. Avery, although naturally talented as an attorney, often didn't prepare the way Mr. Brackman wanted her to. In early 2020, after the regional mock trial competition, Mr. Brackman criticized Avery's lack of preparation. Avery, frustrated with Mr. Brackman, made a horrible mistake. With what she believed was a dry erase marker, she wrote on Mr. Brackman's 1986 Porsche Worst Attorney Award. Mr. Brackman, discovering this, kicked Avery off the team. The next day, Avery made multiple attempts at reconciliation, but never succeeded in apologizing in person to Mr. Brackman because of his tragic death. After Avery tried to apologize on March 5th, the day before Mr. Brackman's death, they went to the Fry Shack. The Fry Shack is a local restaurant a lot of the students on mock trial like to go to. There, Avery let Alex Cifuentes play a game on her phone, even though Alex and Avery aren't the best of friends. The next morning, March 6th, the day of the murder, Avery discovered her phone had gone missing. The last place she remembered seeing it was at the Fry Shack. You are going to hear a lot about cell phones and cell phone towers today, supposedly proving Avery was at Mr. Brackman's house. However, Avery did not even have her phone on the day of the murder. And if she didn't, who did? There are lots of unanswered questions in this case, and we hope today those questions will show that there is reasonable doubt. There are lots of truths also within this case, but what we also hope to do is to help you understand the whole truth, not only the selected truth. And the truth is there were suspects that were not pursued. The truth is there's evidence that is missing or corrupted. The truth is the police performed an incomplete investigation. Now, although there was some high school drama between Avery and Mr. Brackman, this drama did not rise to the level of murder Avery is being charged with. Avery and Taylor were with each other on March 6th, the day of the murder, the entire day. After spending time with Taylor looking for her lost phone, Avery Becker, a high school student, was suddenly a suspect in a murder case. But you will hear from Avery herself today. She will offer her firsthand account of what actually occurred March 6th. Next, we will have Taylor Perkins, a good friend of Avery's, confirm her alibi and share a second perspective. Lastly, we will have Blake Van Owen testify, who is an expert in police practices and will speak on where the police may have missed possible factors in this case. I would like to remind the jury of jury instruction 2. Every person charged with a crime is presumed innocent. Avery Becker is presumed innocent. This presumption of innocence remains throughout the entire trial, and the burden of proof is upon the prosecution today to prove beyond any reasonable doubt that Avery committed this crime. The defense will prove that there is reasonable doubt. The defense will offer the facts within this case. The defense is here to uncover the truth, the whole truth, and nothing but the truth. And after you see the lack of evidence in this case, we ask you to give the verdict of not guilty. Thank you.
All right, thank you. Prosecution, call your first witness, please.
Your Honor, the prosecution calls Detective Markowitz to the stand.
All right, Detective Markowitz. I'm not sure I can see you. There we go.
I'm right here, Your Honor.
Detective Markowitz, if you would raise your right hand, please, ma'am. Do you swear affirm that the matter said, do you swear affirm the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth according to the rules of the mock trial exercise?
Yes, I do.
All right. Prosecution. And before we start, let me have you, the prosecuting attorney, if you can state your name in the event that some of the scorers can't not read or they don't have the tab at the bottom, or they can't read it for some reason, so that they know who you are, please.
Of course, Your Honor. My name is Jaylee Hepner.
Okay, go ahead.
Thank you, Your Honor. Good afternoon, Detective Markowitz. Can you please state your first name and spell your last for the record?
Yes. Jordan Markowitz, Marklwitz.
Thank you. Would you recognize the defendant if you saw them?
Yes.
Is the defendant in the courtroom today?
Yes.
Can you please describe the defendant, Avery Becker?
Yes. She has her hair half up, is straight and black, and she has a dark blazer on with a tan shirt.
Let the record reflect that this witness properly identified the defendant.
The record will so reflect. Go ahead.
What is your occupation?
I'm a Denver Police Department homicide detective. I've been on the force for about 13 years, and I've been a detective for 7 years now, where I do work with crime scenes.
Do you have any other specialized training?
Yes, I have a cell phone technology and forensic data recovery certificate from the American Academy of Law Enforcement. To get it, I had to complete a 3-day training course and pass a certification test.
What did you learn?
I mainly learned about how to obtain and analyze cell phone call records and cell tower data.
How often do you use this in your work?
I often use CDRs or call detail records to find information about how a crime was committed and when it was committed. These records track with a cell phone, which tower a cell phone connected to, and the communications going to and from that cell phone.
How many cell phone tower records and cell phone records you've obtained?
I've used these skills in over 100 cases, and I've looked at cell tower data over 50 times during my work.
Your Honor, under Rule 702, I offer this witness as an expert in the fields of cell phone technology, forensic data recovery, and crime scene investigation, as her expertise, training, and education have been shown.
Defense, do you have an objection?
Your Honor, a brief voir dire, if I may.
You may.
Good afternoon, Detective Markowitz.
Good afternoon.
So you are currently a homicide detective?
Yes.
And you've been with the Denver Police Department for around 13 years?
Yes, I have.
But only a detective for 7 of those years?
Yes.
And you do have specialized training in cell phones?
Yes, I do.
You have a cell phone technology and forensic data recovery certification?
Yes.
And is it correct that it only took a 3-day training course to get that certification?
That's correct.
Your Honor, I have no objection to this witness being entered as an expert as long as they stay within the bounds of the bounds of the restrictions that they're being entered as.
All right. Ladies and gentlemen of the jury, a witness has been qualified as an expert by education, training, or experience, may state opinions. You should judge expert testimony just as you would judge any other testimony. You may accept it or reject it in whole or in part. You should give testimony the importance you think it deserves, considering the witness's qualifications, the reasons for the opinions, and all of the other evidence in the case. Ms. Hepner?
Thank you, Your Honor. How did the crime scene look when you arrived?
When I arrived at the scene at about 2:20 p.m., Mackenzie Brackman was lying face down in a pool of his own blood in front of his house next to the murder weapon. I noticed that the house was in disarray when I got there.
I direct your attention to exhibits 1, 3, and 5. Do you see these exhibits?
Yes.
Can you please identify them?
Exhibit 1 is a picture of the victim laying face down, and you can see the Ring doorbell on the front of the house. Exhibit 3 is a picture of the knife wound in the victim's back, and Exhibit 5 is a picture of the knife and the murder weapon as it was found at the scene.
Are these true and accurate copies?
Yes.
Your Honor, I move exhibits 1, 3, and 5 into evidence as their authenticity and accuracy have been shown.
Ms. Hartman? Do you object?
Your Honor, in pursuant to Rule 7.4, I do request the opposing counsel is able to view these items as well.
That's fair.
I am going to share them after they're admitted.
Well, let me ask this then. Ms. Hartman, do you know what exhibits she's talking about? Exhibits 1, 3, and 5. Have you seen those before?
I could not tell you what is specifically on those, and that is the reasoning why I would request that the defense sees them before they are entered into evidence.
Your Honor,
Okay,
if I may.
that's fair. Go ahead and show them to opposing counsel, and then we'll deal with the admission.
Oh, sorry, Your Honor. I actually was wondering if I could respond to that.
Go ahead.
Under Rule 7.4, it does not attorneys do not have to show the exhibits until they are admitted into evidence.
That's a little unusual. Going on, if that, well, let me ask Ms. Hartman, do you agree that the representation of 7.4 is accurate?
Your Honor, if I may, I believe that the only reason that the prosecution would be withholding sharing these might be because of the jury seeing them before they're published into evidence, swaying their opinion. But under 7.4, the jury is instructed to disregard any exhibit showed or screen shared over Zoom until the exhibit is published into evidence.
Okay. Well, I'm going to.
Your Honor, if I may, I'm not withholding them. I was just simply wanting to get them into evidence so then I could screen share them and then my witness will properly identify them and go into more detail.
Okay. Well, if we were all here and we were all in the courtroom, the way that this would occur is that the witness can see them and opposing counsel can see them. And until there is opposing counsel knows what it is that you're talking about, the jury would not see them. So let's do this. Let's go ahead and screen share them so that the defense can see them, but they're not yet admitted into evidence. You'll need to ask to do that later. I know it's a little bit cumbersome because of the electronic process that we're doing as opposed to everybody being in the same room, but let's do it that way, okay?
Okay, Your Honor. This is Exhibit 1.
All right.
This is Exhibit 3, and this is Exhibit 5.
Okay. All right. Now, having seen them, Ms. Hartman, do you have an objection to the admission of Exhibits 1, 3, and 5?
No, Your Honor.
All right. Exhibits 1, 3, and 5 will be admitted. You can go ahead and publish them to the jury and show them to the witness as well.
Thank you, Your Honor. Permission to publish to the jury electronically since we are not in person.
You may go ahead.
Thank you, Your Honor. Can you please describe these exhibits in more detail?
These exhibits show the victim lying on the front porch or beside the front porch, on the one on the south side of the house, and you can see these Ring video doorbells in Exhibit 1 especially. These exhibits show what is clearly a stab wound in the victim's back and also surrounded by blood soaking his shirt.
Thank you. Your Honor, may I stop screen sharing?
You may.
Moving on, what else did you notice at the scene?
I noticed that there was a Ring video doorbell on the porch, like I previously stated, one on the south side of the house that faced a gate in the backyard, and one aimed towards the back door.
I direct your attention to exhibits 12 and 13. Your Honor, permission to screen share these exhibits?
You may.
Without going through the content, can you please identify these exhibits?
Exhibit 12 shows the perpetrator going in through the back door, and Exhibit 13 is the perpetrator coming out through the front door after the crime was committed.
Are these true and accurate representations?
Yes.
Your Honor, permission to move these exhibits into evidence as their authenticity and accuracy have been shown?
Ms. Hartman?
I have no objections, Your Honor.
Exhibits 12 and 13 will be admitted. Go ahead.
Permission to publish the jury electronically?
You may. Go ahead.
Thank you, Your Honor. May I stop screen sharing?
You may.
From what you concluded, who was in these videos?
From all the evidence I've seen and from these videos, I think it was Avery Becker in the videos.
Why?
Avery has a very similar build to whoever was in these videos.
Moving on, how did you start your investigation?
First, I checked Brackman's ID and realized he had a mock trial shirt on. I investigated this further and found out that he worked at Colorado High School. I contacted the school and received the team members' contacts. This is when I spoke to Alex Cifuentes.
Who is Alex Cifuentes?
Alex was another student on the mock trial team with Becker. I found out through text messages between Alex and Becker that Becker had been kicked off the team for vandalizing the victim's car and wanted desperately to get back on the team.
What did you do after you found this out?
I wanted to do an interview with Becker, but I couldn't, so instead I got a search warrant for Becker's phone. It was apparently lost, so all I could get were the CDRs from the phone, which I got through Becker's old phone number. I made a diagram of these records.
Your Honor, permission to screen share Exhibit 16?
Did you say 16?
Yes, Your Honor.
Go ahead.
Without going through the contents, can you please identify this?
Yes, this is the diagram that I created showing the cell phone tower data.
Are these true and accurate copy?
Yes.
Your Honor, I move to admit Exhibit 16 to evidence as its authenticity and accuracy have been shown.
Ms. Hartman?
Your Honor, I have no objections.
Exhibit 16 will be admitted. Go ahead.
Permission to electronically publish the jury?
You may. Go ahead.
May I stop screen sharing, Your Honor?
Yes, you may.
What did you find on these CDRs?
I accessed the records for all the communications made to and from Becker's phone during the time of the murder. I found that there were multiple incoming texts and phone calls going to the phone. At this time, Becker was not answering any of these texts or phone calls.
How did you discover this?
From the cell tower records, I could see that the phone was connecting to the cell tower closest to Brackman's home. Since the phone usually connects to the tower closest to it, the defendant's phone was near Brackman's house.
What communications were made?
At first, there were 2 texts from Taylor Perkins closer to Becker's house. Then, later, closer to Brackman's house, there were a few more calls and another text, all from Perkins and all unanswered.
Then what did the records show?
Then, all communications and connections suddenly stopped. The phone was most likely put into airplane mode and destroyed, so it stopped connecting to the cell towers. There are several things that could have happened after this.
What was the timeline you concluded?
Avery Becker left her house around 12:45 or 12:50 p.m. and headed down Rock Creek Parkway to Brackman's house. They then were at his house from 1:05 to 1:17 p.m., where the defendant committed felony murder.
Based on the evidence you gathered, what did the crime on March 6th look like?
On March 6th, Becker broke into Brackman's house through the back door, assuming that he would be at work, but was surprised to find Brackman meet them at the back door holding a knife. Somehow, Becker came into possession of this knife and stabbed Brackman in the back. Becker ran out of the home. Brackman, in an attempt to get out of the home, fell and died in a puddle of his own blood in the front doorway of his house.
Based on the evidence you gathered, who killed Mackenzie Brackman?
The defendant, Avery Becker.
No further questions at this time, Your Honor.
All right. Ms. Hartman, does the defense have any cross-examination of this witness?
Yes, Your Honor.
Go ahead.
So you were assigned to investigate the death of Mackenzie Brackman,
Yes, I was.
and you were called onto the scene of the crime
Yes.
on March 6th, 2020,
Yes.
at the address of 444 South Flower Street, Mackenzie Brackman's residence.
Yes.
And you observed the crime scene yourself.
Yes, I did.
You observed Brackman's dead body,
Yes.
and you also observed a large bloody knife.
Yes.
And another thing you observed was blood drops on the floor. Is that correct?
That's correct.
But are there pictures of these blood drops on the floor?
No, the files got corrupted, so we don't have those pictures anymore.
Were there any backups made?
No, there were not.
What about the images of the blood splatter at the crime scene?
Those images were also corrupted.
And no backups were made of these either, were they?
No.
Now, you also observed the Ring video security system camera,
Yes.
and you identified the same height and build of Avery Becker.
Yes.
So you know the height and build of Avery Becker.
Yes, I do.
And how do you?
I know this just from, I'm a detective, so why wouldn't I?
Okay, moving on. Now to the victim. You knew Mackenzie Brackman before you were assigned to the case. Is that correct?
I was acquainted with him, but I didn't know him very well.
And you had been cross-examined by him in court. Is that correct?
That's correct.
And you even considered these encounters with him a displeasure?
Yes,
Objection, Your Honor.
Grounds?
Improper lay opinion. Or, I'm sorry, improper character opinion.
Ms. Hartman?
Your Honor, if I may ask for more explanation on that objection?
Well, you're asking her about her relationship with Coach Brackman, and as he is dead, he is not here to talk about it or really do any, he can't talk about it, and it really doesn't matter how their crosses were between them. It's more or less improper character evidence on our victim, Mackenzie Brackman.
Ms. Hartman, do you have a response?
Your Honor, I'm simply just establishing any possible relationship that Detective Markowitz could have had prior to being assigned to this case. And this could suggest a reason for bias towards or against this case, knowing the victim prior.
Court will allow it. I think any contact that this witness may have had with the victim in this case, it's up to the jury to determine whether or not it serves as a motive or any bias may be present, which would cause the detective to testify in a certain fashion or another. So that the objection is overruled. Ms. Hartman, go ahead.
Thank you, Your Honor. Would you like me to re-ask my question?
Yes, that'd be great.
So you considered these cross-examination interactions that you had with Mr. Brackman a displeasure?
Yes.
Because he would attack the poor police work of you individually and your department?
Yes, he would.
Now moving along to your practices, did you ever interview Avery Becker?
No, I did not.
But you know her height and build?
Yes.
You also interviewed Alex Cifuentes?
Yes, I did.
And did you look at his phone?
I did not look at the phone in particular, but I did receive screenshots of the texts.
Did he not bring his phone to the interview?
No, he did not.
After the interview, did you request for him to bring his phone to you?
He said he would give me screenshots, which I thought was fine. A lot of times people get stressed out when they're coming to police interviews, which I totally understand, so it makes sense.
So you only have the screenshots?
That's correct.
All right, now with Avery Becker's phone, is it correct that a phone usually connects to the closest cell tower?
That's correct.
But does it always?
Not always, but in this case, well, usually when a phone is not connecting to the nearest cell tower, it's because the nearest cell tower is too busy for that connection. So it connects to one that's more empty. But in this case, none of the phones were in busy areas, and so it just doesn't make sense for it not to be connected to the nearest one.
How would you necessarily know if it was a busy area?
Well, there's not really, it doesn't make sense for the defendant to be in any of those areas.
But it's possible if the cell tower was busy that the phone could be miles away and still connect to that cell tower, even if it's not the closest one.
That's very unlikely though, so. Yeah.
Is it possible though?
Yes, it's possible.
Your Honor, I have no further questions for this witness at this time.
Redirect, Ms. Hebner.
A brief one. Again, based off of the evidence you gathered, what cell tower did Avery's phone connect to?
Avery's phone was connected to the cell towers between Becker's house and Brackman's house the entire time during the murder.
No further questions, Your Honor.
Is there any recross, Ms. Hartman?
No, Your Honor.
All right. All right. Thank you, Detective Markowitz. You can step down. Prosecution, call your next witness, please.
The prosecution calls Alex Cifuentes to the stand.
All right, and Mr. Cifuentes, if you would raise your right hand, please, sir. Somewhere. Mr. Cifuentes, are you there?
Yes.
Okay, there we go. All right. Do you swear from the testimony about to give this man will be the truth, the whole truth, and nothing but the truth according to the rules of the mock trial exercise?
I do.
All right. And if I can have counsel for prosecution identify themselves, and when the counsel for defense starts questioning, have that person identify themselves as well, just so that the record is clear. Ms. Delfalo Daly.
My name is Olivia Delfalo Daly. I am directing Alex Cifuentes.
Okay. All right, go ahead.
Hello, Mr. Cifuentes. Could you please state your name and spell your last for the record?
Alex Cifuentes, Sifuentes.
May I call you Alex? And please tell the jury a bit about yourself.
You may, and I'm a senior at Colorado High School. Last year, when I was a junior, I was on the mock trial team coached by Mr. Brackman.
Did you enjoy it?
I loved mock trial, and I was good at it. I was a great lawyer, a good witness, although being a witness is a bit strange in real life. But I was on the team with two people in this room, Avery Becker, the defendant, and Taylor Perkins.
Do you personally know Avery Becker?
Yeah, and it's still pretty hard to take the stand against her.
What's your relationship with Avery like?
Well, Avery was my best friend and is actually the person that convinced me to join mock trial. We were pretty evenly matched, and even though I liked Avery, Coach Brackman, not so much.
Why was that?
Well, Avery constantly antagonized Coach. Brackman wanted a flawless and prepared team. On the other hand, Avery scoffed at preparation. It caused some problems.
What kind of problems?
Well, they argued every single practice. It was preposterous.
What did they argue about?
Well, Avery winged everything and Brackman hated it. It caused 3 huge blowups. I used to joke that they would kill each other, but I never expected fate could be so literal.
Could you tell the jury about the first blowup?
Sure, the first one started because Avery was late. Again, for like the upteenth time. Brackman hit a boiling point and his fury was beyond evident.
What happened next?
Well, Coach Brackman demoted Avery to B team. It was a huge slap in the face because Avery was a senior.
Did Avery stay on the B team?
No, Avery was on B team for like a minute.
How come?
Well, Avery convinced Taylor Perkins to quit mock trial altogether. I left the team. It left the team in a really bad spot when Taylor quit. We needed to fill the empty slot. So after a 5-minute timeout, Avery was on A team once again.
Was that the end of blowup number 1?
Yes, it was.
Okay. When does blowup number 2 start?
Well, after that, we went to regionals and Avery improvised as always. And Avery even won Best Attorney Award, which is the holy grail of mock trial. So I was a bit peeved.
Why?
Well, I worked extremely hard on my materials, and Avery just walks in, conjures perfection out of nothing, and completely wraps a jury around her finger. But c'est la vie. Besides, my frustrations were dwarfed by Brackman's.
Why was that?
Well, Avery hadn't the faintest touch of prep, and Coach told Avery that in the real world, in a real court case, just winging it would be malpractice. But of course, Avery got all huffy-puffy and stormed outside.
What happened after Avery stormed out of practice?
Well, that directly bleeds into blow-up number 3.
Okay. What happened next?
Well, what happened next was absolutely ridiculous. Avery committed a genuine crime. Avery took a permanent marker to Coach
Objection. Speculation.
Ms. Delfolo?
Reasonably
Speculation.
Based on witnesses' perception.
We haven't laid the foundation that he saw this occur, so you need to lay that first.
Okay. Did you see Avery vandalize Coach Brackman's car?
Yes, Avery wrote Worst Attorney Award with permanent marker on Coach Brackman's hood.
What was Brackman's reaction?
Well, obviously, Brackman was extremely irate and booted Avery off the team for good.
How did Avery being kicked off the team affect the rest of you?
Well, since Avery got kicked off, that would mean we would have to substitute Avery for State. Problem is, mock trial rules say that we can't do that. So that would mean we would have to forfeit State. The whole team was pretty forlorn.
During this time, did Avery ever talk to you again?
Yes, Avery sent me a couple texts.
I am now directing your attention to Exhibit 14. Please identify this.
These are the texts that Avery Becker sent me.
Are these a true copy?
Yes.
Are these an accurate copy?
Yes.
Your Honor, the prosecution moves to admit Exhibit 14 into evidence. Its authenticity and accuracy have been shown.
Ms. Hunter, is there an objection from the defense?
Yes, Your Honor. According to Rule 1002, I request an original.
Response.
Ms. Delfolo?
As outlined in Rule 1003, a duplicate is admissible to the same extent as the original unless a genuine question is raised about the authenticity. Mr. Cifuentes just testified to that.
The objection is overruled. Go ahead.
So, Alex, what is important in these text messages?
Well, the texts start off relatively normal, Avery asking me with help to get back on the team. But after that, it got a bit strange.
How so?
Well, after I said that I highly doubt that Brackman would ever let Avery back on the team after the car incident, Avery said, well, if he's still upset about the car, he's going to be really upset when he sees what I do to his house.
What did Avery plan to do to his house?
Well, Avery going to break into Brackman's house and trash it to really show him.
What was your response?
Well, I had a pretty rational response. I thought it was a terrible idea, but of course, Avery didn't listen.
The texts stop here. How do you know Avery didn't listen?
Well, because I saw their troubled relationship firsthand. I saw Avery destroy Coach Brackman's car. Avery sent me texts threatening to destroy Brackman's house. Then somebody did break into Brackman's house, and now my coach is dead. That's how I know.
Regarding your relationship with Avery, are you and Avery rivals?
What? No. Avery got me into mock trial. I never saw Avery as a rival. I don't understand why people think that.
And finally, why was Avery a good lawyer?
Well, Avery can convince anyone of anything. If Avery wanted to, she could convince the jury that they themselves had committed the crime. You know, just something to think about.
Thank you, Alex. No further questions, Your Honor.
Cross-examination, Ms. Hunter?
Yes, Your Honor. In your direct, you stated you saw firsthand what Avery wrote on Mr. Brackman's car. You directly saw him write it.
I saw the big words, worst attorney award on Brackman's hood.
Did you see him write it?
I didn't see him physically write it.
You were on the mock trial team with Avery.
Yes, I was.
You spent a lot of time working hard on mock trial.
Yes, I did.
Avery excelled in mock trial with little preparation.
Yes, Avery was amazing.
And that bothered you considering you put more effort in than Avery?
Yeah, as it would. I loved what I did and I worked hard at it.
And it bothered you because you were not as successful as Avery?
I'd say we were relatively evenly matched, but I assume you could say that.
And understandably, it irked you when Avery would come in and make things up on the fly.
Well, yes, it's Coach Brackman wanted us to be prepared, and I respect him for it, so it annoyed me a bit.
Avery won some awards at mock trial.
Yes, Avery did.
And you thought that Avery won those because of good looks and not actual talent?
Yes, I said that.
After Avery was kicked off the team, you said you would try to convince Coach Brackman to let Avery back on?
Yes.
However, you also thought the team was better off without Avery?
Yes, but I'm not going to leave my friend behind. I'm not a monster.
And you were excited you'd be getting a larger role with Avery gone?
Well, yes, who wouldn't? It's mock trial. You strive for better roles.
And Coach Brackman did not end up letting Avery back on the team, did he?
No, Brackman did not, for obvious.
Apologies, you can continue.
I was finished. Sorry.
Because you were on the mock trial team, you are familiar with court proceedings?
Yes.
Following the death of Coach Brackman, Detective Markowitz called you?
Yes.
And you told Detective Markowitz about text messages on your phone between you and Avery?
Yes, I did.
Detective Markowitz then asked you to come in for an interview?
Yes.
And you failed to bring your phone to this interview?
I did. My phone was quite old. It had trouble keeping a charge, so I left it on the charger, because of the stress of going to an actual, to actually testify against a friend. It's crazy.
Yeah. Detective Markowitz has never seen this text conversation between you two, correct?
Well, Detective Markowitz has seen the text conversation between us two because I sent Detective Markowitz pictures of it.
Let me restate my question. Detective Markowitz never saw this text conversation on your phone?
No, Detective Markowitz did not.
And he was the one who instructed you to send screenshots?
Yes, Detective Markovitz said that screenshots would be fine.
And you understand the importance of these text messages?
Well, of course. Otherwise, if I didn't think they were important, I would not have given them to the police.
And you sent these text messages over by email?
Yes.
And the only place these text messages existed was on your phone and supposedly Avery's?
Yes.
You traded your phone away?
Well, yes, it was terrible. It was old. It was in bad condition, and it really couldn't function properly. So I really needed a new one.
And you did this knowing the importance these text messages have in this case?
Yes, but I sent a screenshot, so I assumed it would be no big deal.
You had access to Avery's phone, correct?
When is this?
Sorry, allow me to rephrase. I'm referring to when you were playing a game on Avery's phone at the Fry Shack.
Yeah, I played a game for a bit.
And you had access the day before Avery lost it?
Yes, I guess.
And you had access to Avery's phone the day before Coach Brackman's death?
Yes.
You had access to Avery's phone the day that Avery's phone went missing?
The day that... Yes, I guess. If it went missing on the day that I played my game on it.
The only information from Avery's phone or your phone in this trial is a screenshot you made of a text conversation no one else has ever seen?
Yes.
On March 5th, 2020, the day before Coach Brackman's death, one of the last people to handle Avery's phone was you?
I would say it was Avery, but yes.
No further questions, Your Honor.
Redirect.
Briefly, Your Honor. Who vandalized Coach Brackman's car?
Avery Becker.
Who did you send the text message screenshots to?
Detective Markovitz.
When did you get a new phone?
I got a new phone not too long ago. I was, I needed it, so I got a new phone not too long ago.
And finally, did you take Avery's phone?
Like, for the game, yes. Like, steal it? No, why would I do that?
No further questions, Your Honor.
Any recross, Ms. Hunter?
No, Your Honor.
All right, thank you. Before we call the next witness, court's going to take about a 60-second recess, sort of, only because I'm watching the battery on my laptop go down, and so I'm going to change locations where I can plug it into a wall outlet. So give me just a moment. All right. With that, I think we are in a new place, and I think we're in a new place now, and hopefully my battery will get us through the rest of this. Okay, prosecution, can you call your next witness, please?
The prosecution calls Kyle Kuzak to the stand.
All right.
Mr. Kuzak, please state your name and spell your last for the record.
Hold on. We need to have Mr. Kuzak sworn in. Mr. Kuzak?
Yes, Your Honor.
You would raise your right hand, please. Do you swear from the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth according to the rules of the mock trial competition?
I do.
Go ahead. All right, thank you.
And for the purposes of the jury, I'm Peter Briggs as
Thank
Kyle
you.
Kuzak.
All right, thank you.
Also, for the purposes of the jury, my name is Zoe Mans Jackson. Mr. Kuzak, please state your name and spell your last for the record.
Kyle Kuzak, K-U-Z-A-K.
And what do you do for a living?
I'm a crime scene reconstruction investigator. I'm not a police officer, but I am a civilian employee consultant of the Denver Police Department.
And how long have you been in that position?
For 19 years this year, it would be. I'm in my third year of tenure with the city of Denver.
Does your position require any certification?
It does. I'm certified by the Colorado Bureau of Investigation.
Your Honor, I move to admit Mr. Kuzak as an expert witness in crime scene reconstruction, as his experience and certification qualifies him to give an expert opinion under Rule 702.
All right, and is there an objection by the defense?
Yes, Your Honor, and a brief voir dire, if I may.
Go ahead.
Mr. Kuzak, have you submitted a CV to the court today?
No, I haven't.
So there's no way of knowing where you were certified?
In Colorado.
But no institution?
By the Colorado Bureau of Investigation.
Right, so a state, but no institution, just to clarify.
Yes, well, the institution would be the Colorado Bureau of Investigation. I don't have a specific building, though I did not submit that to the court.
And it's unknown how long it took to receive that particular certification.
Are you asking me how long it took? Because it's not unknown to me.
Well, I'm asking you how long it took to receive that certification.
It took actually a number of years and a number of years of education to receive that certification.
But your training and education in the field of CSR work is unknown to the court.
I did not submit a CV, so there's not a document saying that. That's why I'm here to testify.
Thank you, Mr. Kuzak. Your Honor, at this time, the defense doesn't object to Kyle Kuzak being tendered as an expert witness in the field of crime scene reconstruction and investigation, so long as he stays within the bounds, parameters, and scope of that field and doesn't go outside of that.
All right. The witness will be so qualified, Ms. Briggs, or I'm sorry, Ms. Mans Jackson.
Let's start by talking about your work in general. What is crime scene reconstruction?
So crime scene reconstruction is a process by which I, the investigator, take into account the physical evidence collected by the police, and I use analysis techniques, a variety of analysis techniques, to reconstruct the actual events of a crime.
And can you briefly describe your process?
Of course. I approach this in 5 steps: recognition and documentation, collection of evidence, evaluation of evidence, hypothesis formation, and the eventual conclusion.
Now let's go ahead and talk about this specific case. Can you describe the recognition of evidence as it pertains to this case?
Of course. I used a witness tracking spreadsheet, which I do in all of my cases, to summarize the pieces of evidence, mostly photographs that I received from the police.
And after this documentation and recognition, what do you do?
Well, then I move on to my second and third steps, which I begin my collection of evidence by visiting the crime scene. I like to get a sense of the layout of rooms, position of furniture, in order to really be able to construct how the crime occurred. And then I move on to evaluating the evidence by linking certain photographs and pieces of evidence into evidentiary relationships.
And can you give an example of an evidentiary relationship in this case?
Of course. One of the most prominent that I saw was between photographs, particularly between photographs I had of blood spatter on the walls and ceiling around the front door, and a photo of a small trail of blood leading from the kitchen to the front door, and finally the evidence that the knife and the body were found at the front door. I was able to link these photographs.
And how did you link these photographs?
These photographs together created a clear chronology that Brackman was stabbed in the kitchen, moved to the front door, and then removed the knife from his back, creating that blood spatter and promptly dying of blood loss.
Mr. Kuzak, I'm going to screen share Exhibit 18 if I have permission by the judge.
You may go ahead.
Without going into its contents, please identify this exhibit.
This exhibit is a photograph of a collection of scuff marks that were found at the crime scene.
Is it an authentic copy?
It is.
And is it an accurate copy?
It is.
Your Honor, I move to admit Exhibit 18 into evidence as its authenticity and accuracy have been shown.
Mr. DeSalvo?
No objections, Your Honor.
Exhibit 18 will be admitted. Go ahead.
And permission to publish to the jury.
You may. Go ahead.
All right, and I will stop screen sharing now. Can you tell the jury about these scuff marks?
Of course. I received this photograph from the police, and using my CSR analysis tactics, I concluded that these scuff marks were created by a scuffle, close combat between at least two individuals.
And through the process that you described earlier, what did you conclude from the evidence?
Taking into account all the evidence that the police provided to me, some of which I described in court today, I created event segments, which are enhanced evidentiary relationships, and I strung those together to create the eventual story, which began with the ring videos you saw earlier, with the perpetrator, Avery, checking the front door, finding it locked, and wrapping around to the back of the house.
And what happened after that?
Well, see, unbeknownst to Avery, Brackman was home at the time and was alerted to the presence of this devil mask intruder, and so tried to find himself a defensive weapon, turning to the large Chicago cutlery chef's knife from his own kitchen. And so when Avery entered, he was ready.
And then what happened?
Well, they engaged in this close combat just inside and to the right of that back door. And they were engaged in this combat, moving through the kitchen, knocking over plates, causing havoc, until the intruder had wrestled the knife away from Brackman's grip.
What happened after that?
Well, Brackman, seeing this, constrained the intruder in a big bear hug, but unfortunately, Avery was still able to wrap around and stab Brackman in the back with the knife. Avery then fled, opening the front door and leaving, and Brackman, in an attempt to follow, got only to the front door before he pulled the knife out, and the coroner's report indicates he was likely dead before he hit the ground.
No further questions, Your Honor.
Mr. DeSalvo, cross-examination.
Yes, Your Honor. Mr. Kuzak, you're not a police officer, correct?
No, I'm not.
And you visited the scene of the homicide after other members of the crime lab had processed it?
I did. I don't go to collect evidence. I go to get a sense of the layout of the house.
And you're very thorough with your work, correct?
I am.
You memorialize, document, and organize all evidence?
I do. Evidence provided to me by the police.
You even use witness tracking sheets to summarize points of information, which you also then review?
Yes, that's one of the documents that is an important part of that organization.
And if I were to show you that witness tracking sheet that you used, would you recognize it?
Of course.
Your Honor, I would request that what has been marked as Exhibit 17 is screen shared.
All right, go ahead.
Mr. Kuzak, do you recognize what has been marked as Exhibit 17?
I recognize this first page. Could you go to the last page? It was kind of fast. Yes, I do. This is, I recognize this.
And what is it?
It's Exhibit 17. In order, it's my witness tracking spreadsheet, my evidence tracking spreadsheet, that's what you can find on this second page, and finally, my rudimentary flowchart of the chronology.
And is it in the same condition as you saw it last?
It is.
Your Honor, at this time, I move to enter what has been marked as Exhibit 17 into evidence.
Ms. Mans-Jackson, do you have an objection?
No objection, Your Honor.
All right, the exhibit will be admitted. Go ahead.
And permission to publish to the jury, Your Honor.
You may, go ahead.
Thank you. There are a few names on this tracking sheet that aren't mentioned in your affidavit, correct, Mr. Kuzak?
That is true.
And Taylor Perkins even goes so far to mention Blair Rollins.
Yes, that is true.
So you failed to investigate a possible suspect in this crime that was mentioned by a witness?
failing implies that's part of my job, but it's not. My job is not to investigate suspects. It's to take the evidence collected by the police. So whether or not Blair Rollins was investigated, that's not part of my job.
But you didn't look into the possibility of Blair Rollins being a suspect?
No, I didn't.
Yes,
I did consider Blair Rollins as a suspect, as one of these three suspects, when I was formulating my conclusions.
And on the topic of suspects, Alex Cifuentes is marked as suspect number 2, correct?
That's not true. I have Alice Cifuentes listed as suspect number 2.
Well, irregardless of the spelling error, that would indicate Cifuentes, correct?
Yes, that's correct.
Right. And from the ring videos, you concluded that the individual in the video matched the general height and build of the defendant?
I did.
And at this time, Exhibit 17 can be on the screen share. But you can't be certain of this given that the perpetrator had on a mask.
That is true, and no DNA was found, but I took into account the 3 suspects provided, and I found that Avery was the culprit.
But it could be really anyone that size that matches the general height and build of the person in the ring video. Correct?
I don't think so. I believe that it's Avery. In my professional expert opinion, it's Avery Becker.
As you said, there were no fingerprints or DNA recovered from the site.
That's true.
So there's no forensic evidence to pinpoint who exactly killed Mr. Brackman?
That is, well, video analysis and the videos collected, I would consider forensic evidence, but you'd be correct in assuming that there's nothing beyond those videos.
And you also believe there was a struggle that ensued?
There was.
Which left scuff marks?
Yes.
But these scuff marks can't be carbon dated, so there's really no telling of how old they are, correct?
That's true. It could indicate a much older struggle, but it would be an awfully strong coincidence.
But just to clarify, and of course a yes or no answer will suffice, those scuff marks could have been created maybe even 2 years prior to Mackenzie Brackman's murder.
That is possible.
For all you know, correct? But Mr. Brackman was stabbed as a result of the struggle that you allege happened.
Yes.
And they fought over the murder weapon that Mr. Brackman introduced.
That's true.
So 2 parties fought, and the winner of that struggle killed Mr. Brackman.
That's true.
Alrighty, no further questions, Mr. Kuzak, and Your Honor, no further questions at this time.
All right. And Ms. Mans-Jackson, do you have any redirect?
Yes, Your Honor.
Go ahead.
Mr. Kuzak, was there enough evidence for you to come to a conclusion about this case?
There absolutely was. In my expert opinion, the culprit, when provided these 3 suspects, Blair Rollins, Alex Cifuentes, and Avery Becker, the culprit identified in those ring videos is Avery Becker.
And in your professional opinion, what do the scuff marks that you just spoke about in cross-examination indicate?
They indicate, through my analysis, I concluded that they indicate a struggle. I took into account the fact that it could have been the result of a much older struggle, but I found it much more likely that that struggle, which we know happened exactly at the point where the intruder entered the home, that struggle was much more likely a conflict between the victim and the intruder.
Thank you, Mr. Kuzak. No further questions, Your Honor.
All right. Thank you. Does the prosecution have any other evidence or testimony to present?
No, Your Honor. The prosecution rests.
All right. At this time, I confess I'm not sure if the rules, the mock trial rules, allow for an argument on judgment of acquittal, motion for judgment of acquittal. But I think what we're going to do is proceed with the presentation of the defense case at this point in time. Is the defense prepared to call their first witness?
Yes, Your Honor.
All right. And Ms. Hartman, who's your witness?
The defense would like to call Avery Becker to the stand.
All right. And is it Ms. or Ms. Becker? Ms. or Mr. Becker?
Ms.
Okay. And Ms. Becker, let me have you raise your right hand if you would, please. Do you swear from the testimony about to give in this matter will be the truth, the whole truth, and nothing but the truth, according to the rules of the mock trial exercise?
Yes, Your Honor.
All right. And in real life, what we would have before the defendant ever takes the witness stand is an advisement to the defense or to the defendant that she need not testify and what rights go along with that, but we'll dispense with those for this exercise. So, Ms. Hartman, go ahead.
Yes, Your Honor. Thank you. Good afternoon, Ms. Becker. Please state your name and spell your last for the record.
My name is Avery Becker. That's Becker.
Who are you?
I am a former Colorado high school student and a former CHS attorney from the mock trial team.
Why are you here today?
Honestly, right now, I'm kind of asking myself the same question. I'm being accused of something unimaginably sick and horrendous that happened to my coach, Brackman.
How would you describe your relationship with your coach, Mr. Brackman?
During mock trial, me and Brackman had our ups and downs. We didn't get along too well because our personalities clashed, mostly because he wasn't a fan of my work ethic, and sometimes he'd get frustrated when I would perform well in competitions without putting in the particular work he expected me to.
How long did you compete for Mr. Brackman?
I competed for Brackman for the entirety of my high school career. I started my freshman year as a way to kind of get out of the house, and after that I developed a passion for it, and I continued it until I graduated last year.
Now, you mentioned that you and your coach, Mr. Mackenzie Brackman, had a rocky relationship. What caused that strain?
Well, after a regional tournament last year, I decided to play a childish prank on him, and I wrote on his card what I thought was dry erase marker.
You thought? What kind of marker was it then?
It ended up being permanent marker, and I cannot express how sorry I was, and I still am. I tried to apologize to him multiple times in person, but I was never able to. I did send him a text message to apologize, but it was supposed to be a lighthearted prank.
How did he react to this?
Brackman seemed pretty upset with me. He was so upset, in fact, that he ended up kicking me off the team.
After you were kicked off the team, what did you do?
I did everything that I could to try to make things right. I offered to scrub all the marker off myself and save up my money so I could get his car repainted, but he told me that I could just join that loser, Taylor Perkins.
Who is Taylor Perkins?
Taylor's my best friend. We joined mock trial to hang out most of the time, and getting kicked off the team together allowed us to spend more time together outside of mock trial.
Where were you on March 5th, 2020?
On March 5th, I went out with Taylor Perkins. We went to Fry Shack for a little and saw a few of our mock trial teammates there, and went to the mall for a while after that. But towards the end of the day, I did lose track of my phone.
And what happened on the following day? That would be the 6th?
On the 6th, me and Taylor decided to call off school in order to look for my cell phone. We went back to the mall to check around, and we also went back to the Fry Shack, but I couldn't find it anywhere. Taylor tried calling it, but it just went straight to voicemail, so I just assumed that it was lost or stolen.
Stolen? Who would have had the opportunity to steal your phone?
Well, actually, at the Fry Shack, the last person that had it was Alex. As you heard earlier today, he was playing a game on my phone, and that's just the last time I remember having it.
Who is Alex?
Alex is another one of my teammates from mock trial, but me and him didn't get along too well.
And why was that?
I felt like Alex didn't want me on the team because maybe he thought I would get best attorney again, and it seemed like he really wanted that award.
And finally, if Mr. Brackman was here today, what would you have to say to him?
If I could see my coach.
Objection, this is irrelevant.
Ms. Hartman, respond to the objection, please.
Yes, Your Honor. This is relevant just due to the fact that I am giving my witness an opportunity to express how she feels on Brackman personally without regarding any specific situation, just addressing her relationship and how being able to reflect on her decisions in the trial that we've discussed today.
May I
Well, you
respond,
can
Your Honor?
specific instances that the witness had with Mr. Brackman and those sorts of things. But your question was, what would you say to him today if he were here? And the objection is well taken and sustained.
Yes, Your Honor. I can rephrase my question as well.
You can do that.
Can I have a minute to confer with co-counsel?
Sure.
Yes, Your Honor, I'm ready to proceed.
All right, go ahead.
Can you explain your relationship a little bit further with you and your coach, Mr. Brackman?
As I said before, me and Brackman did have a rocky relationship, but in hindsight, I can see that I acted extremely childish in my situation, and I did put our team in jeopardy. I just wish I could have proved myself to him while he was still here.
Thank you. Your Honor, at this time, I have no further questions for this witness.
All right, cross-examination.
Yes, Your Honor.
Ms. Mance-Jackson.
Hello, Ms. Becker. I'll begin by asking you about your relationship with Mr. Brackman. Do you understand?
Yes.
So you were on the Colorado High School mock trial team for all 4 years?
Yes, as I said in my direct, I joined my freshman year and continued up until my senior year.
And you and your best friend, Taylor Perkins, saw mock trial as a way to hang out?
Yes, we did at first, but after a while, I found success in mock trial and I actually became extremely passionate about it. So I ended up continuing.
All right. When your coach frequently caught you not paying attention with Taylor Perkins, he was unhappy.
Yes, as I said before, me and Brackman had different ways of finding our success. For me, it was sort of I put things together as I saw fit, and he wanted us to put all of our time into mock trial and developing our case, and that's
So
just
that's
the way that I learned.
So that's a yes.
Yes, as I said at the beginning of my sentence.
All right. In the future, a simple yes or no answer will often suffice. Coach Brackman called you lazy.
Yes, but in this particular instance, a yes or no will not suffice. I think it's fair for the jury to be able to understand my side of the story as well. So Brackman did call me lazy. However, all individuals have their own ways of working through content and finding success. And although he did call me lazy, I did receive awards at my regional tournament and provide success for my team.
So he said you were lazy, yes?
Yes.
And he also said that you didn't put in work, yes?
Yes, but as I said before, I still maintain success.
All right. In fact, you even think that your coach hated you.
I did believe that at some points. It seemed like Brackman was not a fan of how I chose to go about mock trial, and he never congratulated me. So I did feel that way sometimes.
That's a yes.
Yes, at the beginning of my sentence, I said that.
Right. In fact, you think there's only one person who hated Coach Brackman more than you did, correct?
Yes.
All right. Implying that you hated your coach as well.
I wouldn't describe hatred. Hatred's a very strong word. At some points, me and Brackman did have a rocky relationship and we did clash. It was difficult for me to work with my coach at some points, but hatred is a word that I don't think stands true in this particular situation.
So to be clear, your sworn testimony here today is that you didn't hate your coach?
I said that there's some person that hates him more than me. He, as in a strong dislike. It was a maluse of diction on my part, but hate, just in regards to a strong dislike at some periods of time.
So that is a yes. There's only one person who hated your coach more than you.
Yes, I suppose.
Objection, Your Honor. I don't believe that this attorney is letting my witness explain her questions to the best of her ability and what she deems important for the jury to hear, as she has proved that this question isn't a yes or no answer.
Well,
May I respond, Your Honor?
hold on. You'll have an opportunity to respond to that or follow up with that on redirect. The objection's overruled.
All right. Ms. Becker, when did you lose track of your phone?
I lost track on March 5th at the Fry Shack after Alex had been using my phone to play a game.
And it's your sworn testimony here today that you lost track of your phone on March 5th.
The day that I actually figured out that I didn't know where my phone was the 6th, but the last time I remember having it was on the 5th. Yes, that's correct.
All right, so you lost track of it on the 6th, not the 5th, which is what you said.
No, the last time I recall having my cell phone was on the 5th, and I didn't discover that it was gone until the 6th, but I have no recollection of having my cell phone on the 6th at all. So that does mean that I did lose track of it on the 5th.
Yes, but you are saying that you realized it on the 6th, correct?
Yes.
All right, so let's go back to talking about the team. When Taylor Perkins quit the team, after that following scrimmage, Brackman didn't congratulate you on your performance. Is that correct?
No, he did not.
All right, and that made you angry.
Yes, I was pretty upset at that point. I thought I had worked pretty hard to succeed in my own way, in which I did, and it might make me sound vain, but I thought congratulations would be nice from my coach.
So that's a yes, you were angry.
Yes, I was upset.
And you threw insults at your coach.
I did, which was a childish move on my behalf, but I was pretty upset at that point.
All right, in your statement, you called Brackman a lousy attorney.
Yes, I did.
But Brackman was successful enough to own a Porsche.
Yes, I suppose.
Let's talk about that car. When you left that night, you had a permanent marker in your hand.
At first, I didn't think it was a permanent marker. I initially thought that it was a dry erase marker. So I thought when I wrote on his car that it was just going to come off like a whiteboard. And it wasn't until afterhand that I discovered that it was a permanent marker.
Right, so the marker in your hand was permanent, despite the fact that you thought it was dry erase, it was permanent.
Yes.
And you were angry.
I was upset, yes.
As a result of your actions that night of drawing on the coach's car, you were dismissed from your team.
Yes, I was.
And then you lied to your mother about the cause of your dismissal.
I did at that point in time because I was finding it difficult to tell her. So I just told her that I was kicked off the team.
So that's a yes, you lied.
Yes.
And you were even angrier than before.
Yes, I was pretty upset.
So angry that you told your mother you'd get back at Brackman if it was the last thing you did.
I did say that. I was pretty upset at that point in time, and I think a lot of us say things that we don't mean occasionally when we're upset, and that was definitely one of those occasions.
So that's a yes, you did say that sentence.
Yes, at the beginning of my sentence, I said yes.
Go ahead and take a look at Exhibit 14, which should be in front of you as it was admitted into evidence.
If you could present it as we're doing this online, yeah.
Sure, permission to share my screen, Your Honor?
Yes, please.
All right. Oh, sorry, just give me one moment. This is not the right. There we go. Exhibit. These are texts sent from your phone.
They could be from my phone. I'm not sure, honestly.
Objection, Your Honor.
Just
Hearsay.
The Exhibit 14 was already admitted, was it not?
It was, Your Honor.
The objection's overruled.
These texts are sent from your phone.
Honestly, they could be sent from any phone with my name on the top of it, if we're being completely clear here.
I'm sorry, are you saying that these texts are possibly not sent from your phone?
I did not send these text messages, but I have not had my phone for a little bit now. So no, I did not send these text messages. And
That wasn't my question, Ms. Becker. My question was these texts were sent from your phone, correct?
Well, I genuinely,
Objection, Your Honor.
I did not send these text messages. I don't know which phone they were sent from. It does have my name on it, but you can change the content of any name.
Objection, Your Honor.
Grounds?
We've already established that these were screenshots from Alex Cifuentes' phone, so I don't find it relevant that my witness is being asked about these screenshots.
Ms. Mance-Jackson?
The relevance here is that these were sent from Ms. Becker's phone, as was established by both experts Jordan Markowitz and Kyle Kuzak. Because Alex was asked about the text, I ask that Avery may also be asked about them.
Well, any disputed issue of material fact is for the jury to determine, and who they believe and what they believe is also for the jury to determine. One thing that is clear is that Exhibit 14 has been previously admitted, and any witness may be questioned about the contents of Exhibit 14. So the objection is overruled. Ms. Mance-Jackson?
All right, Ms. Becker, read silently with me as I read aloud. The first text. Hey, Alex, it's Avery. The next text. I'm sure you're aware that I got kicked off the team. I'm pretty desperate to get back on. You did, in fact, get kicked off the team, correct?
Yes, I did.
And you were, in fact, desperate to get back on the team.
Yes, I did, but there was also a plethora of people that also had this knowledge prior to this.
So that's a yes, you were desperate to get back on the team.
Yes.
Keep reading silently with me as I continue to the third green text. Come on, please, it's really important to me. Mock trial was really important to you.
Yes.
A while ago, you heard Alex Cifuentes testify that you asked Alex for help getting back on the team.
Yes, I did. I actually contacted my entire team just to see if there's any way anybody could help me out a little bit or maybe reason with Coach Backman.
So you're agreeing that you asked Alex for help getting back on the team?
Yes, but I did not mention a particular occasion. I did text the entirety of the team, so I did not identify a specific occasion where I did.
All right. Permission to stop screen sharing?
You may.
Thank you, Ms. Becker. I have no further cross-examination questions.
All right. Redirect. Ms. Hartman?
A brief one, Your Honor, if I may.
You may.
Following back to Exhibit 14 that was just shared, there's no need to screen share again. Have you seen those screenshots prior to this court hearing today?
No, I have not.
Your Honor, I have no further questions for this witness at this time, and I request that she be allowed to go off the stand.
Is there any recross, Ms. Mance-Jackson?
No, Your Honor.
All right. The witness may step down. Defense, call your next witness, please.
Your Honor, the defense calls Taylor Perkins to the stand.
All right. And Ms. Perkins? Or Mr. Perkins, I'm sorry. Mr. Perkins, if you would raise your right hand, please, sir. Mr. Perkins, are you there?
Oh, yeah, I'm here.
Okay. Do you swear from the testimony about to give this matter will be the truth, the whole truth, and nothing but the truth, according to the rules of the mock trial exhibit or exercise?
Yes, I do.
All right. All right, Mr. DeSalvo?
Please state your name and spell your last for the record.
My name is Taylor Perkins, Perkins.
And who are you?
I'm Avery Becker's best friend, and I was on the mock trial team with her.
And why are you testifying today?
The reason why I'm testifying today is because I was with Avery Becker during the time the crime occurred, and I can attest to her character and her habits.
And how would you describe Avery Becker?
I would describe Avery Becker as a talented individual. She was my best friend, and she introduced me to mock trial. She was a natural at it, so it meant more to her than it did to me. That's why it was unfortunate when, towards the end of our senior year, she lost her position on the team.
Well, once Avery Becker was kicked off of the mock trial team, who did she text to get back on?
When Avery was kicked off the team, she texted everyone she could to try to get back on. She even texted Alex Cifuentes.
And how did Avery feel about Alex?
On the surface, Alex and Avery had a decent relationship, but we all knew that wasn't the case. I mean, Alex had the tendency of being insincere and passive aggressive.
Objection, Your Honor.
Grounds?
Improper character evidence.
Mr. DeSalvo, response?
Your Honor, I just had a moment to gather myself to respond to the objection. So under Rule 405A, this is with methods of proving character. This is by reputation or opinion. And this is Mr. Perkins' opinion on Alex Cifuentes.
And how does that relate to a particular trait that is at issue?
Your Honor, if I may, it could be in regard to the character trait of Alex Cifuentes, in regard to how easy it is to get along with Alex Cifuentes.
Well, you can
personality traits.
The witness can testify as to things that he observed, interactions that he had. The objection is well taken that the witness cannot offer an opinion about whether or not the other person was passive aggressive or not, but the witness can testify as to interactions that he had with that person. So the objection is sustained.
Mr. Perkins, per your observations, what was clear to you about the relationship between Avery Becker and Alex Cifuentes?
It was clear to me that Alex wanted the roles that Avery had and was upset that since he put forth more effort than Avery had, he was upset that Avery was doing better than him and wanted the roles that Avery had, and thus the chance to shine.
Objection, Your Honor.
Grounds?
This is speculation. He has no way of knowing what Alex wanted or what Alex was perceiving to do.
Mr. DeSalvo?
This would be in regard to Mr. Perkins' rationally based perception, given that Mr. Perkins was on the mock trial team with Alex Cifuentes and Avery Becker. Mr. Perkins' testimony in regard to Alex Cifuentes would be pertinent based on his perception.
Well, again, he can testify as to what he saw, what he heard, what he observed, those sorts of things. But he cannot testify about what somebody else was thinking about or what was going through somebody else's mind at that point in time. He can testify if the witness said, I'm upset about this and I want that back. He can say that. He can say, I was there, I heard the witness say that. But he can't reach that conclusion based on other things that the witness had to say. So the objection is sustained.
Mr. Perkins, what did you do that Thursday after school?
After school on Thursday, Avery had swung by the mock trial practice to try to talk to Coach Brackman, but was told to leave. So she came by my house and we hung out and played games on our phones.
And what happened later that evening?
Later that evening, we got hungry, so we decided to go to the Fry Shack to get something to eat. That turned out not to be the best idea, though, because while we were there, most of the mock trial team showed up, and they were all telling Avery how unfair Coach Brackman was being by kicking her off the team.
And where did Avery go?
Avery ran off to the bathroom, and she left her phone behind, which wasn't in character for her.
And how did you know that Avery was really upset?
Avery leaving her phone behind shows just how upset she was, since she always had her phone on her, and when she didn't, it was never too far out of reach. The thing was like her third kidney in a sense.
So, Mr. Perkins, on March 6th, when Avery picked you up for school, What did she respond with through text beforehand?
I usually rode to school with Avery, especially on the mornings when we both had first period off. That's why I thought it was weird when Avery hadn't responded to my text about whether or not we were going to school together. It was only when I asked her about it that we realized that the phone was missing.
Did you go looking for the missing phone?
Yes, Avery and I went to the mall and we searched each store that we had been to see if we could find it. When we still couldn't find it, I remembered that I had last seen the phone the night before on the table at the Fry Shack.
And what else did you do to try to find the phone?
Along with retracing our steps and searching the mall, Avery and I used my phone multiple times to try to text and call Avery's phone while we were out searching for it.
And how long did you spend looking for that phone?
Avery and I had spent the entire day looking for the phone, and when we still hadn't found it, we decided to stop by the Fry Shack to check with the afternoon shift to see if they had seen it. When we got there, we were surprised to see the mock trial team because they should have been in practice.
Who is Blair Rollins?
Blair Rollins is a student at our school, and he was kind of weird, to be honest. I mean, Blair Rollins was the type of kid. Excuse me, could you repeat the question?
Who is Blair Rollins?
Blair Rollins is a student at our school, and he's kind of weird. He had a reputation for hating Coach Brackman, since Coach Brackman had lost the case that sent his father to prison. To me, he was the type of kid to become a hitman or a sociopath in the future, and it wouldn't be that far of a stretch to say that he could do something like that and feel no remorse.
And lastly, Mr. Perkins, who was with you on the day of March 6th, the day in which Mackenzie Brackman was murdered?
On March 6th, I spent the entire day with Avery searching for her phone. We were nowhere near Coach Brackman's house, and I know that Avery had nothing to do with Coach Brackman's murder. I know that for a fact. I'm here to tell the truth and nothing but the truth. I wouldn't lie for Avery, and especially not about something like this.
Thank you, Mr. Perkins. No further questions, Your Honor.
Ms. Hepner?
Hello, Mr. Perkins. I want to start with your time on the mock trial team. Do you understand?
Yes.
You were on the mock trial team.
Yes, I was.
Coach Brackman was your coach.
Yes, that is correct. Coach Brackman was my coach.
You thought he was a mediocre coach.
I wouldn't necessarily say that I thought he was mediocre. I thought that he could have done things to be better, but nobody's perfect. And seeing as he had gotten that far and he had a nice car to show for it, he was a good lawyer. And even though we may have disagreed at times, he was still a good coach.
It's your sworn testimony today that in your statement, you did not say he was a mediocre coach.
I may have thought at times that he was a mediocre coach, and I may have said it, but overall, he was a relatively decent coach. Even though
That's a yes.
Yes, that is a yes.
You would have rather spent time hanging out with friends than going to mock trial.
That is correct. Mock trial wasn't as important to me as it was to Avery, so I didn't really care that much about it. I was just doing it to do it.
That is not what I asked. You would have rather spent time hanging out with friends than going to mock trial.
Yes, that is correct.
You only went to mock trial for the defendant, Avery Becker.
Not necessarily. I did enjoy my time on the team, even though I might not have preferred to spend all my time doing it. But yes.
So it's your sworn testimony today that in your statement, you did not say you only went to mock trial for the defendant, Avery Becker.
That is false. I said that is correct. That was in my statement.
Avery was the best lawyer on your team.
Yes, that is true. She even had the awards to prove it.
However, Coach Brackman would have disagreed with this.
Coach Brackman didn't think that Avery put in as much effort as she should have, but since Avery was an
actor, Your Honor, the question calls for Mr. Perkins to speculate.
Ms. Hepner?
Well, as stated before, considering the relationship between this, and as in his statement, he says that Coach Brackman would have disagreed with this. It's a rationally based opinion, It's not necessarily speculation since it's not only in his statement, but it was also shown in the courtroom today.
Well, the objection will be sustained. It's sort of the same objection that you had made a few moments ago. The witness cannot testify as to what someone else thought. He can testify as to what perhaps in some instances someone had said to him, but he can't testify as to what somebody else thought. So the objection is sustained.
Of course, Your Honor. Coach Brackman was always giving Avery a hard time about something.
Yes, that is correct. Their personalities clashed a bit and they didn't always get along.
Whether or not this would have been Avery being a little late to practice,
Could you elaborate?
Avery at times, Coach Brackman was giving Avery a hard time because she would be a little late to practice.
Yes, that is correct.
Or Avery wasn't trying hard enough.
Avery didn't necessarily need to try as hard as other people because, like I said, and as she said, she was a natural at it.
But that wasn't my question. Coach Brackman gave Avery a hard time because Avery wasn't trying hard enough.
Yes, he was giving Avery a hard time because he perceived that she wasn't trying hard enough.
This led Avery and Coach Brackman into a feud.
Like, I wouldn't necessarily say it was a feud. Yes, their personalities clashed at times, but it wasn't a running thing. They didn't actively despise each other. They may have disagreed at times, and there may have been harsh feelings on both sides.
But there was oftentimes argument back and forth with each other, which could be perceived as a feud.
Yes, that is correct.
Which you found to be kind of funny.
Yes, I did. I mean, people arguing back and forth. Sometimes arguments are funny.
But this feud bothered Avery.
Yes, this feud, I think.
Objection, Your Honor. That's another question that calls for Mr. Perkins to speculate.
Sustained.
Avery could have an inflated ego based off of what you saw about Avery.
Avery was good at mock trial, and she knew that she didn't have to put in that much effort. I mean, when you're good at something, didn't you say...
That's not what I asked. Avery could have an inflated ego based on the perception of being best friends on what you saw.
Objection, Your Honor. Relevance.
Ms. Hepner.
This is extremely relevant as we can see that oftentimes the clashing in the relationship between Brackman could have been because of Avery's inflated ego. And not only this, her being upset about being kicked off the team and maybe even trashing Coach Brackman's house could have been because of her ego. It's directly linked to the motive and it is very relevant to this case.
Yeah, I do believe that it goes to motive. The objection's overruled.
Could you restate the question?
Avery could have an inflated ego based off of what you saw.
Yes, Avery could have an inflated ego, but she wasn't irrational.
In your statement, you say Avery could be rash.
She could be rash, but she wasn't irrational.
That's still a yes.
Yes.
Objection, Your Honor. Asked and answered.
Overruled. Ms. Hepner.
Moving on, I'm going to talk about the practice that happened a month before regionals. Avery came to that practice unprepared.
Yes, that is correct.
This made Coach Brackman heated, so he put her from A team to B team.
Yes, that is correct.
So you quit the mock trial team altogether.
Yes, I quit the team because, like I said, mock trial was super important to me. And since it wasn't hurting anybody...
Nonetheless, you still quit the mock trial team altogether.
Yes, that is correct.
Because you knew Coach Brackman would have to put Avery back onto A team.
Yes, like I was saying, mock trial was more important to Avery than it was to me. And since nobody was being hurt by me leaving the team, and since Avery was such a good lawyer, I didn't see it as being much of an issue.
That's still a yes.
Yes.
Your Honor,
Moving on.
Your Honor, if I may, going forward, I would ask that opposing counsel refrain from badgering my witness. and allow him to finish answering questions.
Well, I think that he has been allowed to finish questions or finish answers. The objections are overruled.
Moving on, I'm going to talk about the practice after regionals. You were not there to see the blow up between Avery and Brackman.
That is correct.
You only heard about it because Avery told you.
Yes, that is correct.
Brackman said Avery did not deserve these awards.
Yes, that is correct. Avery didn't think that, Coach Brackman didn't think that Avery tried as hard as she should have.
Nonetheless, that's still a yes.
Yes, that is correct.
So Avery left practice holding a marker and wrote "Worst Attorney" on Coach Brackman's Porsche.
I wasn't there when it happened, so I couldn't speak about that.
It is your sworn statement today that you have no idea whether or not Avery wrote on the car or not.
I know that stuff was written on the car, but since I wasn't there, I can't say that Avery was the one who wrote on the car.
Let me rephrase. Avery still wrote on Coach Brackman's Porsche.
I don't know that Avery wrote on the Porsche. I know that something was written on the Porsche. I wasn't there.
I just said Avery wrote on the Porsche. I didn't specifically say what. So it's yes.
No.
So it's your sworn statement today that Avery did not write on Coach Brackman's Porsche.
No, I don't think Avery wrote on Coach Brackman's Porsche. I know that something was written on the Porsche, but I wasn't there, so I couldn't say if she herself wrote something.
So Avery did not tell you that she herself wrote on Coach Brackman's Porsche?
Objection, Your Honor. There is hearsay in the question, considering Mr. Perkins was not there at the time the Porsche was written on.
Your Honor, may I respond?
Yes, Ms. Hebner.
This is not offered for the truth of the matter asserted here. The truth of the matter asserted is whether or not Avery broke into the house. The second part of hearsay is an out-of-court statement offered for the truth of the matter asserted. As this is not offered for the truth, it is not hearsay.
Well, actually, it's not hearsay because Avery is a party opponent at this point in time, and Rule 801D specifically defines a statement of a party opponent as not hearsay. So I will allow it under those grounds.
Did Avery write on Coach Brackman's car?
Upon further recollection, I remember that she did in fact tell me that she had written on the car, but she had thought that the marker was dry erase, so she didn't think that it would cause permanent damage.
Moving on, he kicked Avery off the team because of this.
Yes, that is correct.
Moving on, I want to talk about the ways you got back on the team, or Avery tried to get back on the team.
Avery tried to get back.
She tried to contact Alex to get back on the team.
She texted everyone she could, including Alex. Yes, that is correct, to try to get back on the team.
Moving on, I want to talk about how you and Avery on March 6th skipped school to find Avery's phone. You guys skipped school that day.
Yes, that is correct.
And Avery allegedly lost her phone.
Yes, that is correct. Avery hadn't seen her phone since the night
Thank
before.
you. You, in this, you forgot that you could have just looked on your phone on the iCloud website to find it.
We were busy looking for it, and that thought didn't come to my mind. Looking back, yes, I see how that could have come up, but we were more
No further questions, Your Honor. Thank you.
Mr. DeSalvo, do you have any redirect?
Yes, Your Honor.
Go ahead.
So, Mr. Perkins, you did say that Avery Becker, you know Avery Becker well. Would she be irrational enough to commit such a heinous crime?
No, Avery would not be irrational enough to commit murder.
And just to clarify, what did you do on the day of March 6th?
On March 6th, I spent the entire day with Avery and we went to search for her phone. We checked the mall and we checked the fry shack. We were nowhere near Coach Brackman's house. And like I previously said, Avery had no part in the murder.
And would there be any reason for you to not tell the truth today?
No, there would be no reason. I'm here to tell the truth and only the truth.
Thank you, Your Honor. No further questions, and barring any recross, I would ask that Mr. Perkins be excused from the witness stand.
All right. Is there any recross, Ms. Hepner?
No, Your Honor.
All right. All right. This witness may step down. Defense, call your next witness, please.
Your Honor, the defense would like to call Blake Van Owen to the stand.
All right. Mr. Van Owen, if you would raise your right hand, please, sir. Somewhere.
Yes, I'm here.
Okay. All right. Ms. Van Owen, sorry. Ms. Van Owen, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, as far as the mock trial rules permit?
I do, Your Honor.
All right. All right. Defense?
Yes, Your Honor. What is your name and spell the last for the record?
My name is Blake Van Owen, Vanowen.
What do you do, Professor?
I'm a private investigator, professor, and an expert witness in police practices.
Where do you work momentarily?
I am a professor at CU Denver and have been teaching a course on police procedures and social justice for about 5 years.
5 years ago, before being a professor in police practices, what was your profession?
I worked in the police force for 9 months. Then I went to private investigation. As I was working, I started to teach a class on police procedures at the Community College of Rockies, and that is how I started to get into teaching.
Did you ever get a degree?
Yes, I got a master's degree from the Ashford University online program for criminal defense.
Have you testified in court before?
I have, and in over 100 cases, and this case is not any different than the many others I've testified in.
In those 100 cases, where were you accepted as an expert?
I've been accepted as a defense expert in the U.S. District Courts for the districts of Colorado, Kansas, and Arizona, and of state courts in Colorado, Wyoming, Nebraska, and New Mexico.
Where have you testified before?
I've been accepted by various courts as an expert 8 times in crime reconstruction, 5 times in cell tower analysis, and 12 times in general police investigation tactics.
Why have you only testified for the defense?
The reason is most prosecution attorneys use police personnel as witnesses to testify. I've worked for the police force before and have taught classes on their procedures. I know how they operate their cases, as I've testified in many of them.
Tell us about your income as an expert.
I charge $225 per hour for research, writing, and investigation work, and $450 per hour for depositions and testimonies. I only ever charge by the hour and never paid for winning.
Your Honor, at this time, the defense would like to enter this witness in as an expert in police investigation, crime reconstruction, and cell tower analysis with an emphasis on crime reconstruction based on her training, expertise, or experience.
All right, defense or prosecution?
A brief voir dire.
You may, go ahead.
You have not provided a formal CV for the court.
No, I've not.
You've been in this line of work for 5 years.
Yes.
No objection to the witness being admitted as an expert.
All right, the witness will be so qualified. Ms. Hunter?
What were you asked to testify on in this case?
I'm testifying on another theory of how Brackman was stabbed, how the evidence of the cell towers do not prove that Becker was there at the scene of murder, and to establish that the prosecution's case is unsound.
What did you review in this case?
I reviewed the police reports, the crime reconstruction conducted by Kyle Kuzak, as well as the cell tower reports and exhibits prepared by Detective Markowitz.
So, Professor, did you conduct a personal investigation?
Yes, I did conduct my own partial investigation in certain areas that I believed were neglected by the police. Based on my training and experience, it is beyond argument here that the police investigation was rushed.
Where did you keep your work?
A copy of my findings are kept in my report.
Would you recognize this report if I provided it to you?
I would.
Your Honor, permission to present opposing counsel and my witness with what has been marked as Exhibit 20?
You may.
Let the record reflect that the opposing counsel has been presented with Exhibit 20.
All right.
You wrote this report, right?
I did. That is my signature at the bottom.
Tell us about this exhibit.
This is my report where I've kept my findings and observations.
Objection. Cumulative. The jury is able to read this for themselves.
So you're saying that the jury is going to get this report as opposed to the witness's testimony? Is that the basis of your objection?
I am saying that may I have a moment?
You may. It's all right.
I rescind my objection, Your Honor.
Okay. All right. Ms. Hunter?
Tell us about this exhibit.
This is my report where I've kept my findings and observations on the case and my own partial investigation.
When did you write this report?
I wrote this report after I gathered all my findings from my own investigation.
Was this written close to the time of Mr. Brackman's death?
Yes, this is after I completed all my observations.
Are these investigations part of your routine work?
Yes.
Your Honor, the defense moves to enter Exhibit 20 into evidence.
Ms. Dalfolo Daly, is there an objection?
No objection, Your Honor.
Exhibit 20 will be admitted.
And we ask permission to publish to the jury.
You may.
If I may direct your attention to page 83. Do you have another theory of how he was stabbed?
Yes, the most likely scenario is that Brackman would have been in a seated position and stabbed from behind.
What are those reasons?
The direction of force was applied downward and toward the aorta.
What does this suggest?
This suggests that the assailant was positioned above the victim, as if standing behind the victim who is seated, unlike what the prosecution has thought to be true.
How did you come to these conclusions?
The autopsy shows that the sharp side was pointed downward. The most likely scenario would be for the knife to held in the position shown in the movie Psycho or on this page of 83 in my report.
What can you say about this picture on page 83?
If the assailant stabbed Mackenzie Brackman from behind, holding the knife as shown, the wound would precisely match the wound that the medical examiner observed.
Okay, thank you for sharing screen. Why do you believe that Brackman was surprised by the intruder?
For the assailant to match the description, there is no way that they could have performed the bear hug stance to stab Brackman in an attempt to wrestle the knife from Brackman's hands.
Why?
The assailant was about the same size as Brackman because of the intruder's stature. The only logical way would be for them to stand over the victim and exert much forward pressure to be able to stab through the scapula and nick the aorta. This leads me to believe that Brackman was surprised.
Were there any other reasons?
Avery Becker, a mere high school girl, would not have been able to wrestle a grown man and stab him in the back. This is just not reasonable. I also believe that Detective Markowitz clouded Kuzak's judgment and furthermore his analysis that Avery Becker was the main suspect.
Why does the prosecution not believe this as well?
They do not believe this for two reasons. The scuff marks that they believe show a struggle, and the ring videos that possibly could have alerted Brackman of the intruder.
Speaking of the ring videos, what is your opinion about them supposedly alerting Mr. Brackman?
The prosecution believes that because the victim had a Ring doorbell, they immediately assumed that it would have alerted or notified Mr. Brackman and that he was able to arm himself.
Why do you think differently?
We do not know for a fact that the Ring video notified him because Detective Markowitz failed to obtain this critical information that we will never know from the user settings of Brackman's phone. The Ring notifications can be turned on or off, and the app can be set up to not have notifications.
What if the Ring did notify him?
Even if this did happen, Mr. Brackman may not have been.
Objection. Calls for speculation.
Ms. Hunter?
Your Honor, this is an expert within the fields of police procedures and is speaking within their expert opinion on this subject.
So your question is, based on this witness's expertise, she should be able to answer the question of what would be the likely response by Mr. Brackman if he received a notification. Do I have that right?
Yes, Your Honor.
The objection's overruled. I'll let the witness testify. Go ahead.
Can you please restate the question?
Yeah. What if the Ring did notify him?
Well, even if this did happen, Mr. Brackman might not have been near his phone, or he may not have been paying attention to notifications as they come in quickly.
What is the result of this?
Given the fact that Brackman may not have been notified of the intruder, Brackman would not have been armed readily and would have been caught unaware. This means that the intruder would have most likely brought the weapon, which shows premeditation, and this points to another suspect with more motive.
What is your thinking on the murder weapon?
There are many differences between the one in the knife block and the murder weapon. They aren't the same brand, nor the same build, type, or have similar dimensions.
What does this prove?
This proves that the knife most likely came from another source, meaning the intruder. This shows premeditation if they brought a weapon, leading to another suspect.
Tell us about the scuff marks.
The police also noticed scuff marks on the floor and immediately thought it was a result from a struggle. Once again, this is backed up without any evidence. The marks could have been there for a while before this incident. Scuff marks cannot be carbon dated.
Would you say it is common for there to be scuff marks on the floor?
Yes, very, especially at the doors where the scuff marks were found, are a very common place to have these marks.
And what of the broken plate?
This could have easily been a result of being surprised. Mr. Brackman could have dropped it out of shock. This does not prove a struggle.
Why do you believe these observations to be true?
There are no eyewitnesses to the murder, so no one can really know what happened. But when you're trying to put together a puzzle, you can't put a piece down where it doesn't fit. We do not hold the burden of proof today, but the opposing counsel does. And if you can't back something up with proof, or at least common sense, it shows deep holes in your case.
How does this affect the case?
This greatly affects a case. In an investigation, you never assume. But the prosecution did just that. They went straight for the most easy and convenient explanation. There's not much proof to what the prosecution's theory of the case is. I just explained to you all that their biggest points are not backed out with any evidence.
What can you tell us about the cell tower records?
In an urban area, a cell tower covers roughly a circular area of 6-mile radius, but there are 3 sectors in one cell tower. Each sector corresponds to a particular antenna mounted on the cell tower. As such, it is possible to identify which of the 3 sectors a phone connected to was located when it was communicating with a particular cell tower based on which antenna was being used.
How can you tell where the phone was located?
You cannot. A cell tower record is not a GPS tracker. It only gives an approximate location of the phone. The phone could have been anywhere within an approximate 38 square mile location at that time.
Could Avery's phone be connected to any of the towers?
Absolutely. A phone does not always connect to the nearest tower. It connects to the one with the strongest signal when others are busy. The only information that we have is that Avery Becker's phone was in contact with a cell tower near Mackenzie Brackman's residence near the likely time of murder.
Does this mean Avery was at the murder scene as Markowitz suggests?
No, absolutely not. The cell tower does not show where the phone is located, only within a 38-mile radius approximation. This does not prove that the phone was at the murder scene, let alone Becker, who has an alibi.
Why do you believe that the evidence points to another suspect?
I feel Blair Rollins is a person of interest that should have been investigated immediately.
Why is that?
Rollins has a similar build to Becker, who they assume is the intruder, which matches the fit of that person in the Ring videos. Rollins has also suspiciously gone missing around the time of murder and was not at school that day.
What is the reason for his motive to murder Mr. Brackman?
You see, Brackman was a representative of Rollins' father, Johnny Rollins, at a trial for which he was sent to jail. There's an incriminating recording of Johnny stating he would get back at Brackman if it's the last thing he would do, making this a possibility that the police failed to follow through with.
One final question. As an expert witness, from the evidence you've gathered, what is your professional opinion on the proceedings?
In my professional opinion, I know that there is reasonable doubt surrounding the prosecution's theory of Becker and this entire case. I found multiple points of evidence that refute many of their conclusions. My observations and conclusions have been drawn from my extensive knowledge that I've gained throughout the years testifying and teaching.
Your Honor, no further questions.
Cross-examination, Ms. Dalfolo Daly.
Before I begin, may I ask how much time I have remaining? Okay.
Okay, I was going to say, I can't tell you that. Somebody else must have to, okay?
It's in the chat.
All right.
You never went to the crime scene yourself.
No, I did not. I reviewed the reports from the police work and Kyle Kuzak.
You agree evidence points to an intruder who broke into the house.
Yes, but that is about all I agree on with the prosecution.
It's possible the scuff marks were created in a struggle.
It is possible, but very unlikely as they cannot be carbon dated.
Thank you. You've answered my question. It's only a possibility the murderer brought the murder weapon on scene.
Yes, but it is very likely that they would have brought it because of the large differences that the knife
Thank you.
has.
Avery Becker was absent from school on the day of the murder.
Yes, as well as another
you.
suspect which I brought, which is Blair Rollins.
Avery's phone records match the route from Avery's home to the victims.
It could, but like I said, they do not connect to the nearest tower, just the one with the strong
Thank you.
signal.
Nowhere in your statement do you say Blair ever threatened to kill Mr. Brackman. And time has been called.
Okay. All right, we'll leave it at that. I don't know if, Ms. Hunter, you have time left on redirect or not, but if you do, I'll allow it.
I do, however, I don't think a redirect is necessary.
Okay. And as time has expired, there would not be a recross if there were a redirect. So this witness can be excused. Does the defense have any other witnesses that it wishes to present?
No, Your Honor.
All right. And are both sides prepared to proceed to closing argument?
The prosecution is prepared, Your Honor.
And is the defense prepared?
Yes, Your Honor.
Okay. All right. With that, we will proceed with the prosecution. Ms. Mans-Jackson?
Yes, Your Honor. Before I begin, may I reserve the balance of my time for rebuttal?
You mean if you have any time left?
Yes, Your Honor.
Yes, that's fine.
Your Honor, opposing counsel, members of the jury, Avery got in, got out, and got even. Avery Becker never got along with her coach, but this angry sentiment at its peak resulted in death. So on March 6th, Avery Becker, acting upon her own building resentment, broke into the coach's house, took a knife, and literally stabbed the victim in the back. She got in, got out, and got even. As the prosecution, we accept the burden of proof. The evidence provided to you today proves beyond a reasonable doubt that Avery Becker murdered Mackenzie Brackman. Let's examine some of that evidence now, starting with the prosecution witnesses. First, you heard the words of Detective Jordan Markowitz, an expert who, based on her evaluation of the evidence, drew the conclusion that Avery murdered Mackenzie Brackman. Next, Alex Cifuentes, a friend of Avery's, testified to Avery's frequent violent behavior through words and actions. The vandalization of the car, the vicious language, and the frequent lies this witness testified to all show a pattern of extreme behavior from Avery. And finally, you heard from Kyle Kuzak, an expert witness. From his testimony, we ask you to remember 3 key things. He, as an expert, knows Avery was at the house based on cell tower evidence. He, as an expert, verifies the sequence of events leading up to the murder, including motive. And most importantly, he, as an expert, knows Avery Becker was the intruder who got in and killed Mackenzie Brackman. The 2 experts on the prosecution side are telling the whole truth, as they are holistically examining the evidence that they have seen themselves at the scene. 3 witnesses also testified for the defense, which I'll go over now. You first heard from Blake Van Owen, where the truth came out. She is paid to be a witness and only ever testifies for the defense when they give her the money to. That fact alone should discredit Van Owen, but going even further than that, Van Owen was never at the initial crime scene, and the way that both experts who testified for the prosecution were. Therefore, her investigation is not comprehensive or reliable. Then you heard from Taylor Perkins, who only further confirmed that Avery was angry. And Taylor Perkins also conveniently happens to be Avery's close friend, which discredits his testimony. Finally, you heard from Avery herself, and she, before you today, verbally confirmed her patterns of anger and lies. She lied about the texts, as in her statement she says she would never ask Alex for help. But in cross-examination today, she says she sent a text to Alex asking for help. She also lied about the marker, and she was even willing to lie to her own mother. The defense has claimed that they are here to tell you the truth, the whole truth, and nothing but the truth. But what the evidence shows you is that the defense is doing the opposite, because Avery lied. Avery also admitted she was angry. She acted upon her own personal hatred for Brackman 3 times, when she vandalized his car, when she broke into his home, and finally, when she stabbed the coach in the back. I implore you to remember the words that Avery told her own mother, that she would get back at Mr. Brackman if it was the last thing she did. Every single thing that Avery said she would do in text message and verbally, she did. The defense brings up jury instruction number 2, but what that instruction actually states is to use your common sense when noting the evidence. And members of the jury, I ask you to use this reason. The doubt needed to acquit Avery Becker must, by the jury instruction I just mentioned, be real, not vague or small, and the evidence dissolves reasonable doubt. The prosecution has done their jobs in proving to you that Avery killed her coach. As the jury, it is your moral and legal duty today to convict Avery Becker of murder in the 1st degree. Therefore, the prosecution urges you to find the defendant guilty because Avery got in, got out, and got even. Thank you.
Great, thank you. Defense? Mr. DeSalvo?
Your Honor, members of the jury and opposing counsel, the truth, the whole truth, and nothing but the truth is important in this case as it is in every case. And the truth is that the investigators on the side of the prosecution got in, got out, but they failed to do their jobs. There is one time that the prosecution told the undeniable truth in this case, and that's when they said they have the burden of proof. Now, before I get into this deplorable investigative work on the side of the prosecution, allow me to read you jury instruction number 2. It says, if you, the members of the jury, find from the evidence that the prosecution has failed to prove any one or more of the elements of a crime beyond a reasonable doubt, you should find the defendant not guilty of that crime. Members of the jury, all it takes is one, but the prosecution's case is riddled with doubt. Now, I want to get into this body detective work. First of all, Blair Rollins was a suspect mentioned in this case, but Blair Rollins was never followed up on, was never investigated, was never treated as a real suspect. There is a person out there who could be responsible for the murder of Mackenzie Brackman, but the investigators didn't even care enough to follow up on it. Members of the jury, there is doubt in regard to who murdered Mackenzie Brackman. We also have to talk about the smoking gun in reference to, the side of the prosecution in regard to a struggle. They claim that the scuff marks are clearly and directly tied to a struggle existing, but in cross-examination, Kyle Kuzak admitted that those scuff marks can't be carbon dated. We don't know when those scuff marks appeared. Those scuff marks could be 2 years old for all we know. Members of the jury, there's doubt in regard to when those scuff marks were created. We also have to talk about these text messages and the validity of the text messages. It's very possible that these text messages could be doctored for the reason that the investigators did not care enough to bring the phone into custody, even after Alex Cifuentes offered to give them the phone. These are just screenshots, members of the jury. These photos could be doctored. We don't know who sent those texts. We don't know who altered those texts. There is doubt in regard to the validity of those texts. But while I'm on the topic of Alex Cifuentes, let's talk about the testimony that he delivered to you today. Now, in direct examination, Alex Cifuentes proudly and profoundly said that he saw Avery Becker right on Mackenzie Brackman's Porsche, but when pressed on it in cross-examination, Alex Cifuentes backtracked on it, said that he didn't see Avery Becker right on it. Members of the jury, Alex Cifuentes is a person who is very important to the prosecution's case. And Alex Cifuentes lied to you, members of the jury. Alex Cifuentes lied to you. He was not telling the truth, the whole truth, and nothing but the truth. And if he's willing to lie about who wrote on that Porsche, what else is Alex Cifuentes willing to lie about? On the day of the murder, Taylor Perkins was with Avery Becker the entire day. They were looking for the lost cell phone. Avery Becker has an alibi. But also, we have to discuss one of the most interesting portions of this case in regard to what the prosecution has presented. Members of the jury, the prosecution wants you to believe that a grown man, Mackenzie Brackman, struggled with a high school girl, Avery Becker, over a knife. And they want you to believe that Avery Becker, this high school girl, somehow overpowered a grown man, took the knife that Mackenzie Brackman introduced and stabbed him with it. Members of the jury, you saw Avery Becker today. Avery Becker is not a professional weightlifter. Avery Becker is not a WWE champion. Avery Becker is a girl fresh out of high school now. Members of the jury, there is one verdict that you must reach for the sake of justice and for the sake of the innocence of Avery Becker. And that verdict is not guilty, not guilty, not guilty. Thank you, Your Honor. Thank you, members of the jury. And at this time, the defense rests its case.
All right, thank you. And I leave it to the timekeeper and Ms. Mans-Jackson to let me know whether or not there can be a rebuttal in this case. I don't know if you have time left or not.
It has been posted in the chat that I have 56 seconds remaining, Your Honor.
Okay, all right, Ms. Mans-Jackson, go ahead.
The defense stood before you just now and told you that they are telling the truth, the whole truth, and nothing but the truth. But they can't tell you the whole truth because, number one, Avery lied multiple times and even on the stand today when she went against her statement. Additionally, however, there is no whole truth in the defense's entire case because Once again, their only expert was never at the scene of the crime, whereas the two prosecution experts were there and conducted their investigations thoroughly. The defense has two best friends on their side that would clearly never testify against each other, as they've done acts for each other in the past, and one expert who was never at the scene. Additionally, they push this idea of some teen girl being unable to wrestle Mr. Brackman, but I implore you to remember that their own suspect, Blair Rollins, is also a teenage girl. So they're not telling the whole truth, and nothing but the truth, because Avery got in, got out, and got even. Thank you.
All right, thank you. All right, I've done this in the past, and usually what happens at this point in time, we have the conclusion of the case, and then the panelists all retreat to a place where we sort of score our sheets and provide all of those sheets to the proctor. And then we have an opportunity to speak with all of the attorneys and the witnesses and those sorts of things. We can talk to them as much as they like or as little as they like, I suppose. And I'm not quite sure how we do that in light of our current setup. I know that we will need to submit our score sheets, and I don't have a problem with that. But I have other panelists. If one of the other panelists has any comments that they would like to share with either side, perhaps now's the time to do that.
Well, I can start. Can everyone hear me?
Yes.
Yes. This is Phil Dubois. I cut myself out of
just a second. I think we're supposed to submit our ballots before we provide any feedback or hear any feedback from other judges. Is that correct? Competitors sort of nod your heads if that's correct.
Yeah, and this is Jason Downey, the tournament coordinator. Yes, if you could submit your score sheets, I need to have you do that at this time. I will let you know when they've been received, and then that way you can go ahead and give your comments. So if you want to go ahead and submit your score sheets now, and Judge Werner, you may have a problem, so don't worry about it. You stay on until after the comments. Try and keep your comments to around two minutes, not much more than that, so we can get everything in and completed.
Okay. And I'll hold on to mine, and we'll get them done at the end here.
Okay. And if the scoring panelists are familiar with the chat feature in Zoom, I will put a message in there that I received your ballots when I receive them.
And Jason, probably what I'll do is once we get done with all of this, I'll just verbally tell you what mine are in each category.
That's fine.
Okay.
In mind, it may take about 30 seconds for them to come through. And Judge Dubois, I have yours already.
And just submitted mine. You should be getting them momentarily.
Yeah, Judge Almagar, I have yours. And Judge Fitzke, I have yours. So go ahead and keep your comments around 2 minutes per panelist. And Judge Werner, stay on, and I will get with you how to get your numbers. Thank you.
All right.
I guess I'll start. This is Phil Dubois. I'm a lawyer in Colorado Springs. I coached for several years and have judged several more. I am always struck by the fact that every year I'm surprised at how good the competitors are. This is no exception. I am frankly surprised. I just assume that teenage kids can't be, you know, good lawyers, but quite frankly, some of you, well, I should disparage the local bar, so never mind about that. At any rate, what I would say is that both the lawyers and the witnesses were really, really good. I guess the only points I have to make are that if you are doing a voir dire of a witness, it is probably better not to let the witness say everything that the witness already said to get qualified. And it's probably not a great idea to, if you're cross-examining a witness, let the witness say everything over again that he or she did. Some of the witnesses were, well, I don't know, they had a little mental energy and they were willing to fight with you. I like that in a witness. I think that's terrific. So carry on. Your job is to be the character and not give a darn about what the cross-examiner thinks about you. So you just carry right on doing that. And if you're a lawyer, that's very difficult to deal with. As you know, you run the risk of looking like an ogre when you say, shut up, I've asked you the question. On the other hand, you don't want them rattling on. So most of you, I think, towed the line or walked the line pretty well. And that's impressive. I think there were some objections which might have been made, but I know you've studied your case and you've figured out what objections are likely to win and which ones are not. So I don't guess I could dive too deeply in that. So let me just stop there. And once again, good job.
Right. Mr. Fiske?
Well, first I'd like to echo Judge DuBois' comments about what an impressive performance it was. My respects to each of you for doing this in high school. To get in front of people and do public speaking is just amazing. And the preparation, the thinking that you have to do, the public speaking are all going to be skills that are going to carry you through high school and into whatever's next for you. So the real winner in all this is you for doing it in the first place, no matter how the results come out. A couple comments. I liked that both the prosecution and the defense had a theme that was pretty evident. I thought that there was probably too much reading and too much woodenness sometimes with the asking of the questions and the witnesses' testimony. I would just recommend to you that you be a little more conversational in your speaking and a little less kind of reading or rote asking of questions or giving of your testimony. For attorneys, I would recommend working on transitions between points. Some of you did this better than others. You know, we've been talking about this topic and now we're going to move to this topic. Moving on as a transition usually isn't very effective. All it says is, I'm getting ready to talk about something else. Try for a better transition if you can. Objections on relevance, usually a loser. Almost anybody can explain why the question that they're asking is relevant. You should always, as best you can, anticipate objections from the other side and try to prepare for them. My guess is there aren't too many objections that should come as a huge surprise to you. What I didn't do was introduce myself at the beginning. I am a retired Army JAG. I taught for 22 plus years at the Air Force Academy, the law department, worked with the appellate moot court team. So I very much respect the blood, sweat, and tears that you guys have put into getting to this competition. And I've judged a number of these tournaments at the collegiate and high school level. So again, I will end where I started by giving my respects to you for your involvement in this. Nice work.
First of all, I wanted to say congratulations to all of you. I can tell that all of you have worked very hard. I'm a district court judge, and frankly, when I saw part of the video in this case, I had a homicide case that was really similar in that the defendant threw a sledgehammer through a plate glass sliding door, went in, shot his ex-girlfriend in the head, then left and was on video when leaving. And we had blood splatter, we had cell tower records, all of that stuff. So I've seen all of this in actual evidence during trial. I think all of you guys did a really, really good job. The one thing that both of you folks did that is verboten is you, when you were questioning witnesses, you said, or when you were making an argument, you said a person lied. You can't do that. There is a case that prohibits that because it's inflammatory. You can, and we've gotten into all kinds of things of what else can you say? Can you say pants on fire or something like that? But the Colorado Supreme Court has said that saying that somebody lies is inflammatory, and it's so inflammatory that you can't do it. So that's one thing to watch out for. I want to say that all of you did very well. I thought all of you had good presence. I liked that Ms. Hartman went after the expert a little bit on the destruction or loss of evidence and didn't secure other possible phones. And I thought the little lilt when you said something like, okay, so this course that qualifies you as an expert, that was like what, 3 days long? I mean, that was just, it was good. The other things that I saw that were very good, I thought Ms. Hunter did an excellent job. I liked Ms. Dalfolo's presentation. I liked everybody's presentation. I got to tell you, the person that was probably the most sincere and played a teenager to the hilt was Mr. Briggs. He was able, he came across as a teenager. And so I don't know if that was just a natural ability on his part or not, but it came across well. And I thought that on the prosecution side, both Ms. Mans-Jackson, Ms. Hepner, Ms. Dalfolo, Daly, I thought you all did very good in objections in keeping after defense witnesses that were not answering questions the way that you wanted them to be answered. And I think that Ms. Moore she's an expert. I mean, that's every expert that I've ever seen on the stand, that's Ms. Moore. That's how she came across very, very well. I thought all of you did a great, great job. Congratulations. I know that this takes a lot of work and putting your time into it. So you guys did great. And I think Mr. Judge Dubois was going to say that some of you are better than some of the lawyers in town. That's true. So I'll just pass that on to you.
And I'll jump in last here. Good afternoon, everyone. My name is Adrian Almaguer. I recently left a sales career working for companies like Amazon Web Services in Seattle, as well as King County Metro as a senior account executive. I'm starting law school this upcoming fall, so this is very exciting to see. And some of the same comments I had of others, this was very impressive. You all deserve a hearty congratulations for the work that you've done. And I will defer to the attorneys and the judges in the room on actual critiques on argumentation and some of the more process type functions of today. I would say that there were moments where it felt like folks may have been reading from notes, and that was somewhat distracting from some of the argumentation that was taking place. But overall, I think that everyone did a tremendous job, and this is really impressive.
Okay, well, we'll go ahead and end this now, and everybody can leave the room, and I will stay on with Judge Warner, and we'll figure out how to get his score sheet. So thank all of you, and we are going to try and have you in the Judges and Volunteers Lounge for some announcements as soon as we get prepared. So if you want to go to that waiting room, you can do that. You might be waiting a little while, but that's what our intentions are. I will email your coaches when we are ready to start that, so you will know when to go in if you don't just want to go sit there and wait right now. So thank you very much, all of you.
One more thing, Your Honor, on behalf of both teams, we thank you and the scoring panelists for volunteering your time. The fact that we're able to have a season and compete this year with all that's happening, it means so much.
You know, you guys did really great. I'm doing trials by WebEx. I've had evidentiary hearings, and I'm going to start a week-long civil trial on Monday that's going to be by WebEx. And I got to tell you, you guys are great, each and every one of you. You're just great.
Are the judges released now?